Oh, yeah, I see you.
Yeah, I'm gonna put their names in both.
Thank you.
Misha, how do you pronounce your last name?
Jamal.
Jamala.
Yes.
Okay.
Just to be clear, this is the motion for enforcement that's been on file with the court since June of last year? Okay.
And counsel, how do you pronounce your name?
Yuppies.
Yepis. Thank you. I'm ready to do it.
Okay. We're on the record in cause number DF 2011150. Councils, will you please announce for the record?
Michelle Collins, POBLENZ, bar number 24002780 for the father of the.
Thank you.
Cynthia Yuppies, bar number 24115850 for respondent, Mrs. Commissioner Demore.
All right, with those who intend to testify, please stand and raise your right hands. Yes. All right, do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Okay, you may be seated. Prior to going on the record, there were some exhibits that were pre-admitted. They will be admitted at this time. So, Mother's exhibits, should I say this right? Mother's exhibits 1 and 2 are admitted, and Father's exhibits 1 through 4 are admitted. Is that correct?
Yes,
Judge, I understand that it was just exhibit 4 that was presented at the status hearing, the videos, and not 1 through 3.
Okay. Was 1 through 3 presented at the status hearing?
yes.
Okay. What I have submitted from Judge Lee are exhibits 1 through 4. So anything she sends me, that's what was presented at the exhibit conference. Okay. All right. And the motion that is before the court is father's motion for enforcement against mother for allegations of related to enforcement for possession and access that's been on file since June 26th of 2025. Councilors, you all will have 15 minutes aside that will include any opening and closing statements should you all choose to make one, as well as any examinations. Council, would you like to make an opening statement at this time?
I would waive opening, Your Honor, reserve my time.
All right.
I will also wait, Judge.
All right. Attorney Poblins, you may call your first witness.
I call my.
All right. Mr. Augustine, sir, if you have a seat right here in this witness chair and just pull the microphone close to you. Everyone pull the microphone close to you to make sure that my court reporter can write down everything you're saying. And Attorney Poblins, whenever you're ready, you can proceed.
Sir, would you state your name for the record, please?
Yes, my name is George, I'm Steve.
Okay, and sir, you heard the judge, we have 15 minutes, so forgive me if I seem like I'm rushing you, okay? Okay, we're here on enforcement. When is the last time you saw your daughter?
September 2024.
Okay, so a year and a half.
Yes, ma'am.
Okay, we have alleged, that on or about, let's talk about the first allegation, shall we?
Yes, ma'am.
That on May 25th, that's a Friday, May 25th, that at 6 p.m., the mother of your child, the respondent in this case, failed to surrender the child to you. Is that correct?
Yes, ma'am.
Okay. Now, in your original order, those exchanges were supervised. Is that correct?
Yes, ma'am.
And there was a motion to modify that was granted by, do you recall that?
Yes, ma'am.
And in that you received a standard possession order.
Yes, ma'am.
Okay, now, how did you let, other than the court letting her know, but how did you, if you did, let her know that this had been changed?
I printed out a copy of the court order myself, and on my second attempt to try to exercise my possession access, I brought a copy of it myself, and after I knocked on the door and there was no answer, I stuck it in her door. She had a ring camera, so I know, that they saw me doing it, and I also recorded it with my body cam.
Now, how did you know where to go?
Actually, with my private investigator.
Okay, so did she ever notify you of her current address?
No.
Okay, Your Honor, I would like to start with the videos if possible, just for time constraints,
Okay, which,
for A.
all right.
Sir, uh, I don't know,
Are you able, could you pull that down?
oh,
Are you gonna use the Elmo?
if I'm in trouble.
Well, don't worry about it, Chris. Don't worry about it. You would have to connect your laptop to the Elmo.
Okay.
That's the Elmo in the middle.
Okay.
No. This is the Elmo. Yes, this. There are some cords behind here.
I won't trip, okay. Yeah. Oh, I see a name one. This one, no, over to, keep going. I'll stretch.
Yes. I'm trying to troubleshoot you all up here. It's on. So,
It's on?
yeah,
Okay.
the,
Good, it's a start.
and then you're on the left. So. I can see.
Yeah.
It's, he'll pull it down when he comes back. Okay, now you can pull it down.
I won't drop. I'm sorry, Judge, I'm technologically.
No, you're okay. All right, and whenever you're ready, we're back on, Julie.
Sir, can you tell the court kind of what is this?
That's me at Felicia's residence.
Blank trip.
I guess I already knocked on the door, no one answered, so I'm going back to my vehicle. That was the first time that I went.
For 127,
Alright.
as you see it.
One question, could you play the end of that video again? I didn't catch the ending of what he said.
Does not from the door there. Back in my truck. I guess I'll head back to for 127. As you see right there, it says 126 through 129, so it's the next one apartment by the stairs. Better view of the area. And I have absolutely no cooperation, so. Guess I head on.
Thank you.
Yes, sir, just for clarification, this was on May 25th, the third Friday in May.
Yes, ma'am.
I'm sorry, 25th, May 2025, the third Friday in May 2025.
Yes, ma'am.
Okay, and you were there at 6 p.m.?
Yes, ma'am. I was actually there earlier. I sat at the Williams Chicken next door to the apartment complex. That's the video showing that. I was there for maybe an hour before the 6 o'clock hour.
Okay. And you were at 1130 East Ledbetter Drive, apartment 127, Dallas, Texas.
Yes, ma'am.
And that was the third weekend of the month or the third Friday.
Yes, ma'am.
Now, for clarification for the judge, you drove from where?
From Houston.
And you were not happy when I told you to drive from Houston, were you?
No, I wasn't, but I mean, whatever it takes.
Okay, so you drove up here from Houston. How far is that about?
About 250 miles, maybe.
Okay. And then you drove back home.
Yes, ma'am.
Okay, now, let's go down to the second, on May 30th. (2025). And that was actually the fifth Friday of the month. May in 2025 had 5 Fridays. Okay, so you went back and 2 weeks later.
Door, body cam on, so I have recording on me as well. There was no answer to the door, of course. As you see from these videos, she does have a ring camera, so I know the motion to notify that I'm at her door, if wherever she's at, whatever the case may be, so she didn't answer. And I did have the copy of the court order that I printed up this morning, highlighted everything that, she really needed to pay attention to. And I set it on the door above her ring camera. Still here. At our former complex. We're getting ready to head back to Houston for another drive trip. Just don't want to obey the court order. Over there.
Okay, so that was the fifth Friday in May that you drove up from Houston, is that correct?
Yes, ma'am.
Now, just for clarification, you said you left a copy of the order there, where?
I set it in her door
Okay,
next to the ring camera.
okay. And then going on to June 13th, 2025, that's the first Friday in June. Or Kamisha Nicole Jamal Hun. Do you see her here in the courtroom today?
Yes,
Could you point her out for the records?
it's right here.
And what is she wearing?
Black shirt, plaid, black jacket, plaid shirt, eyeglasses.
Your Honor, I would ask the court to take judicial notice that the witness has identified the respondent.
The court takes notice that the respondent has been identified.
Okay, so we're at June 13th. Will you play that video? Sorry, hot.
Time 1:55 p.m. on inbound to Dallas, stay alive, pick up some eyes for the weekend. Which this weekend is also Father's Day and the start of my summer. For the communication with her, I know this is another plane trip. With the city what's going on with my wife accompanies me. As my witness as well. That's it, that one.
Next one. And what is this now, sir?
Today is May.
Oh.
What's today's date? May 13th or June 13th, June 13th,
I think that was the first video.
I just made like.
Oh, wow. That was a video after I returned home and I had spoken to the Dallas Police Department on Camp Wisdom because after that visit, I went over there and asked them, can I go wellness check? Because I mean, I had to ask close order, I had sent it, but get no response, you know, and I was concerned about my daughter and the welfare. I mean, everybody in general, just to make sure everybody was okay, so I asked them to go by. And, I waited until about 8 o'clock, 7:30, 8 o'clock. The police had showed up, so I went on, went back to you. So by the time I made it back, I called and they gave me this information, case number and all this stuff here. So I just wanted to keep it on record.
Okay, and then what's our next video? I'm sorry, I played them out of order. What is this?
That's me on my way to Dallas. That's pretty much what I did every Friday going up there. So I, leaving early, 5, 6 hours in advance to make sure I'm there for 6 o'clock on time. But I mean, this is what I deal with.
So this is the wonderful bumper to bumper traffic on I-45
Yes, ma'am.
heading north to see your daughter.
Yes, ma'am.
Play that. Oh, did it play?
Yes. Let's see, pretty good traffic that I used to have to fight every weekend and make these blank trips. Going about 20 miles an hour.
And were you able to exercise any portion of your summer visitation?
No.
And ultimately, a capias was issued in this case, wasn't it?
Yes, ma'am.
And even after she went to jail, on that capias, did you begin visitation?
No, ma'am.
And when did you actually, get notice from me that she had, stated she would allow you to exercise visitation?
This past weekend and 2 weekends before that.
And so that was after our, status hearing or review hearing going
Yes.
over the exhibits.
Yes, ma'am.
And so she went to jail, you still didn't get to see your kiddo. And you didn't get notice from me until 2 weeks, a little over 2 weeks ago, that she had finally decided to allow you to
Yes.
see your daughter.
Yes.
Now go back to the exhibit line. As part of, the modification, she actually, you guys started using, we're supposed to start using app close, is that correct?
Yes, ma'am.
And, Father's Exhibit 1 is actually, you asking about visitation, is that correct?
Yes, ma'am. Anytime it was my weekend, I always sent her a text message because I mean, I did the app close a million times. And so I would try to send a text message so that, hey, my weekend is coming up. I'll be there at 6 o'clock sharp, and then, hopefully, and can you have it ready? No reply to that either.
So, Father's 1, may I first look at Sean?
Yes.
And when we see these dates, is this 2025 or 2024?
I think it'll be 2025 after we get the court.
And I believe you have Father's 1, Your Honor, but I have a hard
Yes.
copy if you want hard copies.
No, thank you.
Okay. Can you read Father's 1, please? That first page.
Yes, it's text message to the Kamisha. It says, Saturday, June 7th, 11 a.m. Hey, Kamisha, don't want to disturb you. Just want to check on my daughter, make sure she's okay. Can you please accept the app close and let me know about her well-being? Wednesday, June 11, 11:02 a.m. Our Kamisha just wanted to see if you will be available for me to pick up Janaja this weekend. It is Father's Day as well as the start of summer break, so I'm scheduled to have her from June 15th through July 27th.
And did you get any reply from
No.
this? Is that normal?
It has been, yes.
And then fathers too. That approach again, Nora?
Yes. Council, you have 3 minutes and 14 seconds.
Yes, ma'am. Is fathers to your multiple requests trying to get her to join out close?
Yes, ma'am.
Are you asking that the court, sentence her to 180 days in jail?
Yes, ma'am.
And are you asking for attorney's fees and relations for this?
Yes, ma'am.
Pass the witness, Your Honor.
All right, Cross.
Mr. Robinson,
Yes.
prior to this modification, you have supervised visits to the dog, right?
No.
The
We had a court order for me to go to FLP for supervised visits. I submitted all of my paperwork for the intake process and the committee, I never did.
So you did have supervised visits.
No, I never had a supervised visit at all.
Objection non-responsive.
Sustain.
Those supervised visits were ordered because family violence, correct? Yes or no?
I cannot say question, because it's never been
Objection
done.
non-responsive.
Okay.
Overrule, his answer was, I cannot say.
My client will take your daughter to visit you in Houston, is that right?
Well, yes, because she was 3 years old, yes.
So she would supervise those visits for you. Correct,
Yeah, that's what supervision is, yes.
okay.
It was a Christmas holiday, and it was my first time seeing my daughter since she was 3 months old.
And so, as previously stated, you had the opportunity to pick up your daughter about 2 weeks ago, correct?
Yes, ma'am, I did. I was notified that.
Objection non-responsive.
Sustain after, yes, ma'am, I did. Wait for the next question, sir.
But you did not show up to pick her up on, I believe it was April 18th, the weekend of April 18th, correct?
Yes, ma'am.
And you also did not pick her up this past weekend,
Yes, ma'am.
okay? No further questions.
Okay. Anything further of this witness, counsel?
No, no, ma'am.
All right, sir, you may return to your seat. Counsel, you have 2 minutes and 49 seconds left. You have 13 minutes and 22 seconds left. You may call your next witness.
No other witnesses, Your Honor.
Okay. So, are you resting at this time?
Yes, Your
All right,
Honor. I'll reserve my 2.5 minutes for cross.
okay. Counsel, you may call your first witness.
This commission.
All right. Ma'am, just pull the microphone close to your mouth. And whenever you're ready, counsel, you may proceed.
Mr. Law, you state your full name in the court.
Commissioner Code Jim Long.
And were you aware that there was a court hearing on May 5th, 2025 at 2 p.m. via Zoom?
Yes,
How were you notified of that hearing?
I got a letter from the dad's lawyer.
Did you attend the hearing?
Yes, I did.
Did you log in?
Yes,
Were you? What time, do you remember what time you logged in?
I logged in 15 minutes early. And I stayed in the waiting room.
And what happened?
I never got called in to speak about my daughter.
So were you allowed into the virtual courtroom?
No,
How long did you wait until you logged off after 2 p.m.?
I waited 3 hours because it was a message that said sit patiently. And my experience with Zoom is you just have to stay there until they call you.
Did you contact anyone after that?
I did. I contacted the dad's lawyer right after, since it said on the letter that if I had any trouble to call. And I called her and asked her if they had the hearing. I thought maybe they canceled and I wasn't aware. And she told me she wasn't in control of who they let in. And when I was explaining that I never got let into the hearing, she told me that she wasn't in control of who they let in. So I needed to call the courts. So I hung up I called the courts and I didn't get an answer from the court, so I sent an email to Brittany King.
Did you ever get a response from anyone?
I never received a response.
So you never had the opportunity to speak to the judge?
I did not, I never got a chance to speak that day and I did not have a lawyer, so I just waited, I was waiting for a response as to a new court date.
So prior to the May 5th hearing, was there a previous order in place?
There was, we have a lawyer, we had an order that was many years old when Naja was a baby. And because of family violence, her dad was supposed to have supervised visits at the center on Harry Hines. And the judge was nice enough to restrict my address from the judge.
Narrative.
Sustain.
What did that order say about possession and access?
Center only,
Object to relevance, we're not here to talk about the original order.
Sustain.
Were you ever made aware that there was a new court order following the May 5th hearing?
I did get the paperwork that was left on the door with the highlights on the doormat.
Did you speak to anyone about it?
I tried to find a lawyer. I have tried to find a lawyer, tried to understand the paperwork, but I couldn't afford to hire a lawyer to explain everything to me.
Did you understand what it said?
I did not, I was confused as to what it was.
Did you question whether it was a valid order?
I did, I was even confused about the signature of and the seal, state of Texas documents have a seal, I didn't see a seal. It did not compare it to my original order and it didn't look like it was valid.
No further questions, I assume.
All right. Counsel?
Ma'am, after you weren't let in, did you come down here and get a copy of the order?
I did not,
Did you file anything?
no,
Even after you were put in jail for contempt, did you contact my client to begin visitation? Yes or no?
no,
Did you surrender the child on the dates listed, violation 1, 2, and 3?
I don't remember the dates, I didn't surrender her any dates.
So you admit that you committed violation 1, 2, and 3.
I haven't violated anything.
So did you turn the child over the third Friday in May of 2025?
She has not been with her dad alone, no,
Yes or no, ma'am?
no,
Did you turn over the child the fifth Friday in May, May 30th, 2025?
no,
Did you turn over the child for summer possession June 13th, the first Friday?
no.
And even after you were put in jail, did you contact anyone?
Yes,
Did you contact my client?
I don't know how to contact your client.
So you didn't get the text messages?
No, ma'am.
Did you give him your new information?
I do not know how to contact your client.
You've been to his house, have you not, ma'am? Yes or no?
Yes, ma'am.
That's the witness, Shawna.
Okay. Anything further?
Yes. Why did you not turn over your daughter to Mr. White?
It was against the court order that him and I signed.
Is there any other reasons?
Yes, family violence.
Anything else?
Yes, I've tried to stick to my court order and it said visits only with supervision. So I was just following what the state of Texas had ruled with both of us present.
And just to confirm, this past weekend, did he come to pick up your daughter?
He did not,
And have you downloaded app close?
I have.
No further questions.
All right. Anything further from this witness?
No, Judge.
All right. Ma'am, you may return to your seat. Counsel, you may call your next witness.
No further witnesses.
All right. Do you rest?
Mhm.
All right. Sir, how much money did you pay your attorney?
Same as that, yeah. I would have to look at all of the receipts.
Could you give me a ballpark?
$3,563.
Does that include, what do you call those? Service fees? Council?
No, Your Honor, the process server charged us twice at what, 75 each to go out.
What about for the motion for enforcement?
That included,
Okay,
that 3,563 was only for the enforcement, not, we segregated out the motion to modify on the enforcement, Your Honor,
okay.
and I can testify to them. I will have been licensed and all that if you need.
Council, any objection?
Yes, I don't believe she's properly proved up her fees, there's no affidavit in place.
Yeah, which, Your Honor,
Yes. Thank you. Thank you. Is this part of the exhibits? I don't see it.
No, Your Honor, because I hadn't included today, so I didn't know.
Okay.
And prepared.
Did you give council a copy? Yes, just so she can review it to see that, the fees have been segregated. The one I'm looking at, council, it says all enforcement, just FYI.
May I borrow it to show? them?
Yes, you can have it. How many days total? Has dad missed?
Oh, Lord. No, 2 years, so I would have to tell you on the days, Your Honor. So since the order is, I have to total them up, Your Honor.
Okay, since the May 9th order, right?
Yes, ma'am.
Okay. I'm giving council an opportunity to review your billing statement. Council, I don't see it on file. Do you have a proposed order?
Yes, Your Honor.
Okay, what about a commitment order?
We were waiting to see what you wanted us to do, Your Honor.
Okay, I asked that we have those ahead of time, because the sheriff's department, they can't take her into custody without the commitment order.
Yeah, for sure.
Yes. Would you tender a copy to council, please?
We already said.
Whether I change them.
No, no, no. Your Honor, if you want to, have her email of proposed commitment orders.
Yes, please. At this time, what the court is going to do after hearing all of the testimony, the court is going to find that mother did violate the order based on her own admission of never tendering the child over to father. And specifically, according to the motion, the court is holding her in contempt for violation number 3, June 13th of 2025. The testimony and the dates for 1 and 2 conflicted, so I can't hold her in contempt on those. But for Friday, June 13th, 2025, mother is held in contempt. She will be taken into custody today by the Dallas County Sheriff's Office to be held in jail for a period of 30 days. And ma'am, where will the child be? Okay. In that period, wait, the extended possession, it was 42 days, right? That was a Father's Day weekend.
Yes.
So that will be 42 days. The when is the child's last day of school?
It's the end of this month.
Does she have a way to get back and forth to school?
Yes.
Okay, so 42 days, not 30, 42 days. I just want to make sure that it's clear for both of you. Nobody can violate a court order. You have to follow it exactly how it's worded, whether you agree with it or not. And ignorance to the law is not an excuse, ma'am. Your mother, she's going to be your competent adult, because on an enforcement, I can't modify the underlying order. So when it's his opportunity to get the child, your mother has to turn the child over. Okay? I just want to make sure we're clear on that. All right? And I need a commitment order. So you'll just wait, the seat behind you, you'll just wait there, and then I'll wait on the commitment order and sign it. Oh, and the court is going to award attorney's fees, including costs, in the amount of $3,913. Ma'am, how much time do you need to pay that? How much time do you need to pay that? It's $3,913.
A year, 2 years.
Okay, so what I can do, let me look at my calendar.
And does she want the commitment order email directly to you or e-file?
Email directly to Brittany. Yes, yes.
You can.
Oh, and Joe, yeah, you can get it directly to her.
To both. Oh, she's doing that right now.
Okay.
She's doing that right now.
And the fees, the $3,913, that'll be due by August 3rd of 2026. I don't like writing on orders. I like clean orders. So would you mind getting me an order that just has the June 13th date
Yes.
and the contempt language of 42 days for incarceration?
Yes.
Yes, thank you.
Oh, she's getting it to you right now.
No problem. Is there anything else for the record?
No, ma'am, not from petitioner.
Okay. From attorney, is it Yepes? Yepes? Is there anything further for the record?
Judge, I believe that this was a due process issue from the start. I don't believe that my client willfully violated the order. Counsel at the time.
Well, she admitted it, counsel. She admitted it. She said right here on the witness stand, and I have all of the transcript right here in front of me. She admitted that she never turned the child over. So I don't know what to do with that. Okay, thank you. Thank you all. Your excuse.
And So I'll do that one.
Thank you, counsel.
On the outside.
Thank you.
I have my line.
Okay, so we're going to take a brief break and do the wedding.
I really just need my phone. Thank you. What is it like? Take a lot. Right.
Well, I need, no, take out, but definitely. Yeah.
This thing is hot.
Okay.
So I don't have my. Yeah, it's, that's what it's going. So I'm gonna, sometimes I'm decided to fill out everything. Yeah, do that. Alright. Yeah, I'm gonna get a one, or two, I go to the six, maybe. Thank you.
All right, we're on the record in cause number DF 24044935. Councils, will you please announce for the record?
Brandon Berlin here for petitioner Aerial Sites.
Thank you.
Yes, good morning, Judge. Attorney Alexis Linval here for respondent Justin Sites.
Thank you all so much. Will those who intend to testify, please stand and raise your right hand? Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth? Thank you. You both may be seated. We're here today on the First amended motion for enforcement of child support that's been on file with the court since February 25th of 2026. Is that correct? All right. You all will be given, well, prior to that, we spoke about some exhibits that were pre-admitted. They will be admitted at this time. So movements 1 through 4 are admitted and respondents 1 through 7 are admitted. You all will have 15 minutes aside, and that will include any opening and closing statements, should you all choose to make them. Attorney Berline, Attorney Berline, would you like to make an opening statement at this time?
I would briefly, Your Honor.
Okay, you may proceed.
Your Honor, this is our enforcement, mother's enforcement, it's a child support enforcement, Your Honor. We are alleging 15 separate violations of late payment of support. The order that's on file in this case requires child support to be paid on the 1st of each month. And on 15 separate occasions, respondent has failed to pay child support timely. Respondent might say in this case, well, I've paid all of my support and this motion is frivolous. However, I would reiterate to the court that the 5th Court of Appeals in Dallas has said the fact that an obligor may not be in arrears in child support payments at the time of contempt hearing does not excuse the fact that he has not made the support payments on the dates on which the payments were ordered due. And that's exactly what we have here, Your Honor. The late payments have caused my client trouble paying her rent on time, getting groceries for her child. And we need it to stop. We need payments to come in on time. I'll pass. Thank you, Your Honor.
Thank you. Counsel, would you like to make an opening statement?
Yes, Judge, briefly.
You may proceed.
Your Honor, this is not a contempt case. The decree defines delinquency as more than 30 days or a month of unpaid support. Out of the 15 violations mother alleges, this has happened one time. However, every payment was made, and in fact, we believe that the evidence will show that my client has actually overpaid at this point. The OAG financial activity report and the OAG record and both parties' evidence actually confirms this. What we have here, Your Honor, is a timing dispute. We are talking about days, not defaults. This is not willful compliance or willful non-compliance for the purposes of contempt. Accordingly, Your Honor, we are here asking the court to deny Ms. Sites' enforcement and award my client all of his attorney's fees incurred in me having to be here today. Thank you.
Thank you. Counsel, you may call your first witness.
Thank you, Your Honor. I'm going to call my client Aerial Sites.
Ma'am, if you just have a seat right here and just pull the microphone closest to your mouth.
It said there wasn't a signature. I think it was on page 8.
It's on page 9. Counsel, whenever you're ready.
Thank you, Your Honor. Ms. Sites, can you please state your full name for the court?
Yes, it's legally Ariel Park.
Thank you, Ms. Park. There was an order for child support entered in your case back in December 19th of 2024. Is that correct?
Yes.
Okay, and it ordered Justin Sites to pay you $14.72 in current child support.
Yes.
Okay, and it also ordered him to pay you $305.79 in cash notice.
Yes.
And what was the due date for those payments?
The first of every month.
Thank you. And those payments started back in November of 2024?
Yes, that's correct.
Initially, how are you receiving child support payments from Mr. Sites?
via Venmo or Zelle.
Was there a reason why he was paying you directly?
Yes, he said I should not sign up through the OHE because the payments would be late, probably about a month late. If we pay through the portal.
Okay, and he did pay you informally for a period of time, correct?
Yes,
Was that period roughly November of 2024 to May of 2025?
yes,
And you're not disputing that you received those payments?
I'm not
And
disputing that.
you're willing to give him credit for those informal payments?
Yes,
Were any of those payments made on time?
I think the first couple were made on the first two.
Okay, can you take a look at what I have marked as mom's exhibit 1 in front of you?
Yes,
You recognize that?
yes,
Is this an affidavit of direct payments that you completed?
yes.
Okay, and take a look there for me and tell me how many payments that you admit were paid informally were made on time.
One payment was made on the first.
Okay. After May of 2025, did you start receiving payments formally through the state?
Yes, I did.
Have any of those payments been made on time?
No,
I want you to look at what I have marked as mom's 2. You recognize that document?
yes,
And is that a updated child support payment record that we've received from the state of Texas?
yes,
Do you see any dates listed there which show child support payments made on the first of each month?
no,
Is Mr. Sykes employed?
yes.
Is he employed for a company or is he self-employed?
He's self-employed.
And in your order, there was a suspension of withholding, is that correct? Were his payments ever withheld from his paychecks withheld?
I'm not sure if that means.
Does he have an employer that can withhold the child support amount from the paychecks before he gets them?
No, he does not.
Okay, he's self-employed.
Yes,
So he gets to determine when he makes the payments.
yes,
Okay. Want you to look at mom's 3. Are those proof, is that proof of the Venmo payments that were made or Zelle payments made directly to you?
yes.
Okay. What happens when he pays the child support late?
I cannot pay my rent on time and I incur eviction notices and late fees through my apartment
And how often does that happen?
nearly every month.
Okay. Has it given you trouble getting groceries, paying other bills and expenses?
Yes, absolutely.
Okay, and you're here today asking the court to order Mr. Sykes to pay by the first of the month.
Yes, please.
Okay. And we've also asked that the court order he pay a bond. And at the amount of at least $10,000, is that right?
Yes,
And in the case of future enforcements or future late payments.
correct.
Okay. That's what we're sharing.
All right, Cross.
Yes, ma'am. Is your salary approximately $68,000 a year?
Is that before or after taxes?
Your salary, so before taxes.
Before taxes? No, I've gotten raises since that number.
Okay, so what is your annual salary, ma'am?
I believe it's, I just got an increase in March, so I believe it's 85,000 roughly.
Okay, you're earning $85,000 a year.
Correct.
I wanna look at the violations that you alleged in your enforcement, your first amended enforcement. For violation number 1, you're alleging that my client did not pay his December 2024 child support until December 2nd.
Correct.
And you acknowledge that he paid you the support, but that it was 1 day late.
Yes,
Violation number 2, you allege that he paid your January 1st child support on January 3rd.
yes,
So you acknowledge that he paid you, but that it was 2 days late.
correct.
Violation number 3, you allege that he paid you, but he paid you on February 3rd instead of February 1st. Is that correct?
That's correct.
Violation number 4, You allege that he paid you, but he paid you on March sixth instead of March first.
That's correct.
Violation number 5. You state that your April 1st, 2025, or your April 2025 child support payment, you didn't receive that until April 3rd.
Correct.
So he was 2 days late.
That's correct.
You're asking the court to hold him in contempt
Yes.
and potentially have him handcuffed and jailed like we just saw in the hearing before us.
Correct.
When he's a couple days late on child support,
It's been actually 2 months.
objection, non-responsive.
Not a couple days.
Sustain.
When he's a couple days late on child support, you're asking for the court to have him incarcerated, ma'am.
It's been more than a couple days, ma'am.
Objection, non-responsive.
Sustain.
I'm just talking about the violations that we just went over, violations 1 through 5.
Oh, yes, that's correct.
Violations 6 and 7, admittedly, payments were a little bit later this go around. We have May 14th and June 11th, correct?
Yes, that's correct.
And you acknowledged again that you received payment on those months
Yes, correct.
and within the month that the payment was due.
On May 14th and June 11th, what you said?
Yes,
Oh, okay, I need to look at this. May,
ma'am, you've received all the child support payments, correct?
I have not received May yet.
But we're talking about 2025, you have received May and June 2025.
Yes, correct.
In your own exhibit 3, and you just testified to the fact that my client has paid you directly, is that correct?
Yes, that's correct.
Okay, and have you had a chance to review the OAG financial activity report in this case?
Yes, I have.
Okay, and so you're aware that those direct payments are actually not reflected on the OAG financial activity report, correct?
I have submitted all the paperwork needed on my end. I'm not sure why it's not reflected on there.
But you agree with me that the payments that my client made to you directly are not reflected on the OAG financial activity report at this time, correct?
I don't know. I'm not in charge of that, so I don't know why they haven't reflected.
And it's binder in front of you, that's a skinny white binder, if you wouldn't mind grabbing that for me, please, ma'am. If you turn to tab 1 for me, please, Father's Exhibit F1. You acknowledge that you received this letter through your attorney over 2 months ago, correct?
Correct.
And it asked you to non-suit your case,
That's correct.
and you chose to proceed anyways, correct?
That's correct.
It asked you to sign a direct payment affidavit to reconcile the OAG payment log to reflect payments made to you directly, correct?
I have already done that.
Okay. Did you or your attorney ever tell us that you had submitted that to the OAG prior to coming here today?
I believe so. We spoke about that, my attorney and I.
But you don't have any evidence here today that that was provided to us and told to us that it was submitted to the OAG, correct?
I don't believe that that's under my jurisdiction.
So ma'am, would you agree with me if the OAG payment log shows that he's about 1 month behind on child support? You agree with me that that's the fact right now, right?
I'm sorry, can you repeat that, please?
Sorry, that was a confusing question. You agree with me that the OAG financial activity report currently reflects that my client is 1 month behind on his support obligation?
To my knowledge, he is 1 month behind.
And you agree with me that there are a handful of payments that you received that have not been reconciled on the OAG payment log at this time, is that correct?
I don't know the numbers. Whenever I go to see if they've corrected it, I still see numbers in that tab. I don't know what the total is.
Would you agree with me that if the OAG actually reconciled the accounting to reflect the payments that you received directly, my client would actually be overpaid in child support at this time?
I don't, and I don't know where that number came from.
Objection, non-responsive.
Sustain after I don't.
Violation 8 and violation 9, ma'am, of your amended enforcement. You claim that you received the July 2025 child support, but you received it on July 15th, correct?
That's correct.
And you claim that you received the August 2025 child support, but you received it on August 19th, is that correct?
That's correct.
So again, you're not complaining that you didn't receive that child support. What we have here is another timing issue, correct?
That's correct.
Your exhibit 4 consists of your attorney's invoices. When we total it up, we see that you've incurred over $8,000 in attorney's fees, not including what you're incurring today. Does that sound accurate?
Yes.
And yet it's possible, once the OAG reconciles payments that you've received directly, it could show that my client has actually overpaid you by near that same amount.
That is incorrect.
I don't have time to go through all the remaining violations with you, ma'am, but just to be clear, you have received all of the monthly child support payments that you're owed at this point.
Up until May, yes.
May 2026.
May 2026, yes.
Ma'am, do you think it's reasonable that you've incurred over $8,000 in attorney's fees when there's a possibility that you've been overpaid child support?
I don't believe there is any possibility that I have overpaid child support.
Okay, say for the sake of conversation that you have not been overpaid child support, do you still think it's reasonable that you've incurred $8,000 to be here today when you acknowledge that you have received all of the payments that you're owed except for one?
I do, because I've made.
Objection non-responsive after I do.
Sustain.
Do you think it's reasonable that your daughter's father goes to jail over this?
I would prefer he not go to jail.
Ma'am, do you understand that in your amended enforcement petition, you asked the judge to put him in jail over this?
I understand that.
Do you understand my client's self-employed?
I understand that.
And so you understand that you will absolutely not receive child support timely and likely not at all if he is incarcerated.
I understand that.
And you're here requesting that anyways.
I would prefer he's not incarcerated, but yes, I understand that's part of this.
Pass the witness.
Okay, counsel, you have exactly 4 minutes and 58 seconds left. Attorney Berlani, you have 13 minutes and 2 seconds.
Ms. Sykes, we filed a proposed order in this case, is that right?
Yes.
And we asked that the court suspend any commitment of Mr. Sykes, is that correct?
I'm sorry, can you?
We asked the court to put Mr. Sykes on probation, is that correct?
Yes,
Now, you're aware that, counsel brought up the issue of the letter that she sent to us. You recall that question?
yes,
You're aware that prior to that letter being sent to us, I contacted Ms. Linvall. Is that
Yes.
correct? And I talked to Ms. Linvall about the potential to settle this case.
yes,
Okay, and I informed you that I wasn't able to do that.
correct.
And essentially, Ms. Linvall's letter was a demand that we dismiss our case.
Yes,
Wasn't a settlement letter. It was a letter demanding that we dismiss our case and she won't go after her attorney's fees,
yes.
okay? How often have you brought this up, this late payment issue to Mr. Sykes?
It's been multiple times, pleas, emails, texts.
What happens when you bring it up to him?
He tells me that I can take him to court and I can demand that the court take care of it.
Does he take you seriously?
I don't think so.
Even after we filed our case, did he continue to make late payments?
Yes, he continued to make late payments after we filed our case.
Even after we amended our petition in this case, did he continue to make late payments?
Yes, that's correct.
Has he ever made any payments on time outside of the first payment that he made?
No,
Are you claiming that you haven't received all of the child support?
I'm not.
What are you claiming?
I'm claiming that I would like him to pay me on the first of each month, or as close as possible, or at least give me notice to when to expect that I can receive my child support payments.
You believe the court order should be followed exactly to a T?
Yes,
And if the court order were to be followed exactly to a T, when are the payments due?
first of every month.
Okay. Have there been occasions where Mr. Sykes has been over 30 days late on payments?
Yes,
How often has that occurred?
2 times, 2 months.
Do you recall when those months were?
Yes, September 2025 and February 2026.
February 2026, so this year,
Yes,
after we filed our enforcement,
yes,
he paid over 30 days late.
yes,
Was that a slap in the face to you?
yes,
Are you struggling to make your bills on time?
yes.
What does Mr. Sykes do for a living?
He's an interior designer.
Does he work for Home Goods?
No, he works for very high-end residential, primarily residential projects and clients.
Does he make good money?
Yes,
Okay, you used to be married to him, correct?
yes.
Okay, and you separated back in 2023?
Um,
Let me rephrase that. You were divorced back in 2023.
2024, December 2024.
Right, okay.
It
Um,
was
No,
finalized.
you're right. Thank you for clarifying that. Do you recall how much he was making per month at the time you guys were married?
He said he was making about 20 to 25,000 a month,
Okay, and so more than you, right?
much more.
Okay. And has he made any recent purchases?
Yes, he's.
Objection, relevant.
What's the relevance?
Your Honor, she called my client's income into question, implying that she can afford to receive these payments late, I guess. I think it's relevant, for us to show that Mr. Sykes has the ability to pay on time, he just is choosing not to.
Okay, well, you said recent purchases, that could be anything. That could be gas.
Okay.
Okay, go ahead.
Has Mr. Sykes purchased expensive vehicles recently?
Yes,
Objection, speculation.
Would you like to take her on the voir dire?
Yes.
Go ahead.
Ma'am, you agree with me that you've been divorced from my client for over a year now, correct?
that's correct.
Okay, you're not privy to his finances anymore, correct?
That's correct.
You don't go with him to look at vehicles or visit car lots, is that correct?
That's correct.
You weren't there if he were to purchase the vehicle while he was signing the paperwork, correct?
Correct.
So you actually have no knowledge regarding how much a vehicle that he purchased would have cost, correct?
Correct.
Nothing further.
Your Honor, if I could ask one follow-up question.
Go ahead.
Has Mr. Sykes told you about purchases that he's made?
My daughter and Mr. Sykes have told me about 2 vehicles.
Objection, hearsay as to what her daughter has told her.
Sustained.
Sorry, Your Honor.
You have one more question on go ahead.
With regard to what Mr. Sykes has told you, what has he told you about the vehicles he purchased?
Yes, he told me that his second luxury vehicle he purchased was a gift, a client gift in exchange for work, and that the client was unable to pay a past invoice, and so gave him his Porsche.
Okay, so Mr. Sykes is driving a Porsche around, but he can't seem to make his child support payments on time.
And a Range Rover, yes.
I'll pass it over to Your Honor.
Objection, non-responsive.
So, non-responsive, sustained to non-responsive and overruled as to the, relevance. All right, anything,
I pass it over to Your Honor.
okay, anything further from this witness?
No, Judge, thank you.
Okay, ma'am, you may return to your seat.
Thank you.
You're welcome. Counsel, you may call your next witness.
I'm gonna call myself, Your Honor.
All right, you may proceed.
I'm a licensed attorney.
I'll stipulate to opposing counsel's qualifications.
Okay,
Your Honor. I've submitted what I have marked as mom's exhibit 4. Which is, copies of our attorney fee invoices in connection with this case. We've had several, exhibit conferences in this case, I think 2 exactly. I did amend my pleadings after Ms. Sykes sent her letter. Because Ms. Sykes was making the argument that her client, I think essentially she's making the argument that as long as her client pays the child support, it doesn't matter when he pays it, he can pay it late if he wants, as long as my client gets the money. And I disagree with that argument, Your Honor, and so I amended my petition to include case law that supports the fact that even if Mr. Sykes pays, it's not okay that he's paying late. The courts have consistently.
Objection, Your Honor, I don't know how this goes to I don't know how this is relevant to the attorney's fees. It's more like oral argument.
Sustain.
The point I was trying to make, Your Honor, is that I had to do research, and so that increased the costs. We did have to amend our pleading because of it. We did have to serve Mr. Sykes twice in this case. To date, not counting today, my client has incurred attorney's fees and costs in the amount of $8,563. We're asking that the court grant a judgment against Mr. Sykes in favor of my client for that amount of fees. I'll pass it with Your Honor.
Thank you. Any questions for Attorney Berline?
No.
Okay. Would you rest?
I do, Your Honor, if I have any time left, I'll reserve that cross examination.
All right. You have 7 minutes and 15 seconds left. Counsel, you have 4 minutes and 18 seconds left. You may call your first witness.
Yes, thank you, Judge. I'll call my client, Justin Seats.
Okay.
Sorry.
Mr. Sites, just pull the microphone close to your mouth. And whenever you're ready to proceed, counsel.
All right, Justin, I want to quickly address a few things that were testified to. Did you tell Ms. Seats that, or Sites, that you that she can take you to court if she wants to receive her child support payments on time or anything to that effect?
No, I said she could contact her attorney to contact you.
Do you receive paychecks?
I do not.
And there is an allegation, or there was testimony that you paid late even after this enforcement was filed. Do you recall that?
I do.
And why is that?
Because I was coming up with the money to pay the retainer for this case.
Have you been making your child support payments every month?
Yes,
And you acknowledge that your payments are sometimes a few days after the first.
that's correct.
Okay, now let's talk about when you're paying child support versus when it's reflected on the OAG report. My understanding is that there's a discrepancy there. Can you please explain that to the court?
There is the OAG records the payment process, a minimum of 5 days after the payment is actually made. So if I make a payment on the first, every month it's going to show the earliest on the OAG account as being paid on the 6th. There is no direct correlation to the day that I pay and the day that it's shown on the OAG account.
And is that substantiated by the evidence that has already been pre-admitted into court today?
Absolutely, all of my payments show that correlation.
Did you pay May child support yet?
Yes, on the first.
Okay, and again, as we sit here on May 4th, it is not reflected on the OAG's financial activity report. Is that correct?
Correct. It will not be reflected until at least the 6th.
Okay.
That's standard.
As we sit here today, are you behind on child support?
I am not.
Okay, do you believe that you are actually ahead as we sit here today?
I believe so.
Do you believe that once the direct payment affidavit that Ms. Sykes has completed is submitted to the OAG, that will actually show that you've significantly overpaid in child
I
support?
believe so.
Have you ever been more than 30 days behind?
I have, yes.
And when was that?
That was February of 2026.
You understand there's an allegation that you were more than 30 days behind in September of 2025?
Oh, it's not. I made the payment on September 30th and it did not record until the following month.
And again, your bank statements reflect the timing of that.
Correct.
Okay. When did you make that February 2026 payment?
I made it on March 1st along with the payment for March. So I think both at the same time.
And do you recall what date that you made that double payment for February and March of 2026?
On March 1st, and it reflected payment, I think either on the 6th or the 8th because of that OAG delay I was speaking to.
Just to give an example of this, if you look at tab 4 of the binder in front of you, exhibit F4. Go 5 pages from the back for me. Are these snapshots from your bank statement? And Ms. Sykes alleges that you paid the September 2025 payment over a month late, correct?
Correct.
And when did that payment leave your bank account according to your statement?
It left my bank account on September 30th.
So even if you were to pay on the first of the month each month, you believe that she still would not receive it for approximately 5 days.
I am certain that's correct.
Why have you not paid child support exactly on the first day of the month every month?
I am self-employed and my cash flow is not steady. I don't take a typical paycheck. And so I make the payments when I do have the funds on a monthly basis to do so. And it's my first priority when I receive those funds.
Do you intend to pay every month?
I do.
Have you tried to stay current?
Yes, I have.
Are you taking steps to ensure earlier payments going forward?
Yes, ma'am.
Are you refusing to pay child support?
I am not.
Ask the witness.
Right? Cross?
Thank you, Your Honor. Mr. Sykes, you just testified that the September of 2025 payment that you made, it came out on the 30th, is that right?
That's correct.
Okay, and when was it due?
It was due on September 1st.
Okay, so it was paid 29 days late,
It was due on September 1st.
and you paid it 29 days late, correct?
I paid it on September 30th.
Okay, 29 days late, correct?
I paid it on September 30th.
Okay, is that hard for you to admit that it was paid 29 days late?
No, it's not.
Okay.
Because it's due September 1st. But based on our decree, it's not technically in default until after 30 days after the 1st.
Okay. So you think that date that says that you have to pay it on the 1st of each month, you think that doesn't apply to you, correct?
That's incorrect.
Okay. The rules don't apply to you, but they apply to everyone else.
That's incorrect.
Objection argumentative.
Sustain.
If it's your impression that you can't violate the order as long as you're not more than 30 days late, correct?
Objection argumentative.
Sustain. Rephrase.
Is it your position that you can't violate the order as long as you're paying within 30 days of the due date?
That is not my position.
Now you've seen our pleading, correct?
Yes.
There's several violations, in particular 7 through 15, where we've alleged that you paid more than 5 days late. You aware of that?
Yes.
Okay. And so the issue that you're raising in relation to when the OAG processes the payments, how long it takes them to post the payments, doesn't apply to those violations, does it?
The dates that you're showing are still minimum 5 days after the date actually made the payment.
May I approach witness, Your Honor?
Yes.
I'm gonna show you our violations here that we have in our amended petition, 7 through 15. Let's look at 7 through 14. Payments were due on the 1st of each of those months, correct?
Correct.
Okay, and in June of 2025, the payment was made on June 11th.
Is that what the OAG reflects?
Do you have my exhibit, Mom's 3 in front of you? Do you have Mom's 2, actually? Mom's 2?
I don't have any of yours of this.
Should be in that stack to your right. Should be one that's marked Mom Exhibit 2.
Mom's exhibit 2.
Would you agree that this reflects when the payments were posted?
This reflects when they're posted, but not when they're made.
If it takes 5 days, like you said,
Minimum 5 days.
okay. Would you agree that violations 7 through 14 show that you paid? There was more than 5 days. Those payments were more than 5 days late, correct?
That's correct.
And my clients told you about this issue, correct?
We have discussed it.
Okay, and did she make you aware that this is affecting her ability to pay her bills?
She made me aware that it affected her ability to go on a girls' trip.
Objection, non-responsive.
Sustain.
Did she make you aware that this affects her ability to pay her bills?
She did not.
Okay. And your response to her was that she needed to call an attorney.
But this can be handled through our attorneys.
Okay. So you told her to seek out legal representation for this issue.
I did.
And she did that, correct?
Correct.
And that's why we're here today.
That is not what we're here to take.
I'll pass it with the term.
Okay. Counsel, you have 7 seconds left.
I was just gonna call myself for attorney's fees quickly.
Go ahead.
Okay, my name is Lexi Limbaugh. I'm an attorney licensed to practice law in the state
Your
of
Honor,
Texas.
I'll stipulate to the qualification.
Okay.
A Attorney's fees and costs incurred by my client attributable to this matter total $4,406. This does not include the preparation for and attendance at today's hearing, which is an additional $1,125 based upon 3 hours of my time here today. I'm requesting $5,000 in attorney's fees. My invoice are coming at F7.
Thank you, counsel.
Thank you.
All right. Yes, I signed it. Thank you. Sir, you may return to your seat. The affidavit of direct payments, let me just make sure my math is correct. $17,711.11.
Your Honor, ours, I think is a little bit less than that. Ours shows 12,444.53.
12,000.
444.53.
Is that reflected now on the OAG's payment record?
It is not. Your
That's
Honor.
our understanding that it is.
That makes a difference.
And I think if we're looking at Ms. Linvall's F3,
Let me pull that one up.
it shows the credits.
So,
I see $11,000 collection. Well, it's actually 3 collections there, October 5th, October 17th, and October the 22nd for about the amount that you said, counsel.
Correct.
and Your Honor, what I'm looking at is that it shows that there's a payment September 9th, 2024. And then on the financial activity report, there's not showing a transaction for September. So there are transactions that are reflected on both parties' direct payment affidavits that are not reflected in the OAG payment log.
Your Honor, I think that's because the child support didn't start until November 1st of 2024.
So the direct payments wouldn't be on here. That were before that.
Right, so there's been payments made that are not reconciled with the OAG, and yet the OAG is only showing that he's one payment behind. He did make that payment. It's just hasn't shown yet because of the delay.
Right, and
I think those, sorry, I think the September payments were in relation to the temporary order that was in place at the time in the divorce case.
so what I'm looking at, the order says that the child support payments were supposed to start on November 1st, 2024. So if there was a temporary order, anything made prior to that would be for the temporary order.
That's correct.
Yes.
All right.
Just for example, Judge, like there's a one of the payments, like February 2025. For example, there was a direct payment made in February 2025, and then if you look at the OAG financial activity report, there's no collection showing for that month. So again, it's a direct payment made that is not reflected because Ms. Seitz has not submitted this direct payment affidavit, or at least we were not aware that it had been submitted until today's testimony.
I will disagree, Your Honor. I think those collections were made, it looks like between 10/6 of 2025 and 10/22 of 25. It looked like they all were added to the record at that time, altogether totaled.
And this is why I like for the AG to be present, because they can reconcile their own reports. Because I cannot say that someone violated an order without knowing for sure if payments have been made that have not been reconciled on here. Because according to this payment record that I'm looking at, Father's Exhibit 3, he would only be behind 1 month, and it would be consistent with his testimony as of the May payment not being reflected on here. And I believe I need that. In terms of holding father in contempt, I can't hold him in contempt at all. The rule is very straightforward about for child support, if you're seeking to hold someone in contempt, it must not only show the amount paid, it must not only show the amount due, it must also reflect the amount paid, if any. And in the motion, the violation doesn't specify the amount paid by respondent. It just said that his child support payment was due and he failed to timely pay. The court, in order to hold him in contempt, I would have to know what he paid, if anything. So if he made the payment of $1,779 or something less than that, the motion has to specifically cite that. So the court can't hold him in contempt. However, as far as a violation, at this point, with what I have in front of me, I don't even know if I can hold him in a violation, considering that the payment record that I have in front of me is not, it does not contain everything that the court needs for a violation, because from my purview, what I'm looking at, he seems like he's paying child support timely, monthly.
Yes, Your Honor, and just to clarify, our argument was not that he wasn't paying child support, it's that he's not paying it on the first of each month, which is required by the order.
Well, and here's the thing, the Attorney General wouldn't even bring a motion to hold him in contempt as long as the payment is made within the month. Although the order says on the first, as long as he makes that payment during the month, he wouldn't be held in contempt. It's not considered untimely unless he spills over into that next month. And to hold him in contempt for the way the agency updates, I just don't think that's right. So from what I'm looking at, I can't hold him in contempt or even a violation. Are there any other payments that are outstanding? I think the court needs those questions answered before I can even consider if a violation has even taken place, and I just don't have it in front of me.
I think there was at least one payment that was made over 30 days late, Your Honor. That was the recent payment in February. I think the testimony was that both parties admitted that that payment was made over 30 days late. Believe Mr. Sykes admitted that on the stand, and my client testified to that as well, February 2026.
Okay, I see that. Your bank statements reflect the timing of that, correct? When did you make that February 2026 payment? I made it on March 1st along with the payment for March. So I made both at the same time.
And for the record, Your Honor, February only has 28 days. And so he was still within 30 days at that point of when the payment was due. Also, there was testimony that he was paying me attorney's fees to have to defend against this contempt, which was part of the reason for the delay in the payment that month.
The court is not going to punish someone for substantial compliance. No. So the motion for enforcement is denied. Each pays their own attorney's fees. Thank you all.
Sure.
You're welcome.
Okay.
You're welcome. Chris, did the 10:30 or the?
Yes, I believe that both of them, that showed up.
Okay.
Will be following this.
You can, we're gonna take up the wedding.
Okay.
Thank you, Your Honor. Have a good day.
You're welcome, you too. You're welcome.
You ready? Come up.
Good morning.
Yes, sir, you can come up too and record them or take pictures if you'd like. Si usted quiere venir, acercarse para tomar video o fotos, si puede.
Michael Reyes and is it Sarayeth? Saraith. Oh, I like that. Saraith Patricia Leon Castillo. Sayarith. I like it. Are you all exchanging rings today too? Or are you already wearing them? Okay.
Puedes poner así enfrente de ellos si quieres. Como, yeah.
All right. You wanna face each other and
Okay, and that, going from, ready.
yeah, you can stand right here.
Aquí si quieres poner.
Side. I love it. Okay, y'all ready? You ready? Okay. We are gathered here today to celebrate in holy matrimony, the ceremony between Michael Reyes and Sarai Patricia Leon Castillo. Are the two of you ready to proceed with your ceremony?
Yes.
Okay, marriage is sacred. It is a covenant under God and it should be entered into soberly and honestly. Michael, do you take Sarai to be your lawfully wedded wife? To love, honor, cherish her, be honest with her through sickness and in health until death do you part. Sarai, do you take Michael to be your lawfully wedded husband? To love, honor, cherish him, be honest with him through sickness and in health until death do you part. All right, so Michael, you're gonna go first.
Yeah.
All right, repeat after me. With this ring,
With this ring,
I be wed.
I do what?
Do you accept? Okay, and your turn. With this ring, I be wed. All right, do you accept?
I do.
Okay. Well, by the power vested in me and under the authority of the state of Texas, I now pronounce you husband and wife. Michael, you may kiss your bride. Congratulations. Welcome. All right. You see?
Yeah.
Joey, you want to move on? Really likes me in the week. All right, would y'all like to take some pictures?
Yeah.
Yeah. So you go first, and then I'll jump. Yeah. It's much better, Michael.
Yeah. My nerves.
Your life.
Close down.
Okay. And here, you hold your both hold. There you go.
Okay, well now it's.
I don't know if I said shoot or not. Congratulations. I love your name. It's so pretty. And you're welcome. Would you all like to walk that back over, or we could walk it back over for you on Friday? We can do it on Fridays. So to you.
We can do it.
Okay, all right. Congratulations. Nice to meet you. You're welcome.
It's up to you, Judge.
Thanks.
You're welcome. She had sent another one though. You didn't need the same one she sent. Is Michelle?
Yeah, they don't have.
Okay, doesn't.
I need the commitment order though.
I
I just signed the order. All right, are you all here on D of 2413763? Or D of 2115041?
This is Gutierrez.
Gutierrez, okay, that's the first one. All right, is the other attorney here on that one too?
He is, I think he's working out an agreement on one of the other cases with opposing counsel right now outside.
Okay,
That's my understanding.
perfect, thank you. Did you need me?
Yeah, I think then the last people.
Oh, yeah.
Oh, and, you know, that, when we had arrested the lady, the families started trying to get at each other downstairs.
I saw that.
Mm-hmm.
I saw him, old boy, was pissed. Did y'all arrest his ass?
The court is going to take a recess to prepare for the next case. I'll be right back. Okay, so we're still out on Gutierrez? Or,
I think we're all here, but I think that, they worked out an agreement on the case before us, so we're happy to let them.
On
go ahead.
Salcedo.
okay. So Salcedo?
Yes,
Well, hold on 1 second.
Okay,
Yeah, we have an agreement, but let me just tell my client, and we might have to, I guess some things will go away.
correct.
Alright,
I could easily
Okay.
decide that
okay.
change.
Let me tell you real quick.
okay,
We'll probably, yeah, just a couple minutes, Judge. I'm sorry.
no worries. So Gutierrez,
We're fine waiting a couple minutes, Your Honor.
okay.
That's me too.
Yes.
Oh, that's right, you're on both.
Yeah.
Yes, ma'am.
I apologize in advance, because I honestly don't remember for our trial that we had. Do you want the orders emailed, or do you want hard copies?
Email to Brittany.
Okay,
Mhm.
sounds good. And just a copy of the 10-day letter and the orders for you to sign.
Yes.
I apologize, I'm sorry. I don't remember, I'm just gonna have to ask her. So-
Thank you.
Okay, I'll send them right now.
You're with,
Yes.
okay, okay. Why are you sitting all the way over there? I thought you was. I need to eat my break.
The OAG here today. Plus the fair party. Is that gonna be a problem?
Are they agreeing? Yeah, they intervened, right?
We have the financial activity report. I mean, you told us all to come back. Mr.
Yeah,
Silver.
could we reach out? Was it Attorney Sweet or was it
Justin Dale.
Dale? Okay, we'll send an email,
Okay.
see if he can hop on Zoom if he's not in the building. All right, so that leaves us with Gutierrez. All right.
You want me to tell him to hop on Zoom if he's available?
Yes, I think Zoom will probably be easiest if he's not in the building.
Yes, I'm doing it right now. I'm gonna do both of them, Stephanie Sweet also.
Hmm,
You want me to add Stephanie Sweet also, CC her?
yeah, just in case. Did you all want to go ahead and get set up on Gutierrez?
Council, what's your first name?
Matthew Creed.
Your last name? please?
Creed, CREEK.
Great.
Yes, ma'am.
All right. Joey, I think you're, yeah, okay. All right. Check for exhibits. So on exhibits, I have just. Hold on, it's making me log back in. All right. So on exhibits, I show 1, 2, and 3 for father. Then I see mother's exhibits. Is it one exhibit or is it multiple exhibits in one?
It was, Judge, it was multiple exhibits in one PDF, and it was 1 through 9, and I do have those.
Okay. So you want to label those just one?
Well, no, yeah, I want to,
Um,
because for Court of Appeals purposes, we've got to break them, each exhibit their own.
They should be broke down in the PDF with each exhibit sticker.
No.
yeah, she's saying
But-
multiple, like 1 through 9, each
Okay.
one of them. Yeah, so 9 different exhibits.
But, if you wanna just leave this one and just name it one exhibit, then it's got all the exhibits in. If that's okay. with you.
Whatever works easier for you, works for me.
Because they have a thing with the Court of Appeals, we're not able to modify the exhibits once we get them, so it's kind of easy just to put it on the record. Well, that's okay.
I also see space exhibit. The pay record. Did you all get that too? Stace exhibit A?
No, this is only possession and access.
Might be under the wrong one. This is Salcedo, right? No, this is Gutierrez. Yeah, it's under, I have an exhibit on that one. Maybe she got you mixed up because you're on two of the same cases. So mother's exhibits are 1 through 9. Father's exhibits are 1 through 3.
Yes.
Okay, I have it sorted out. You had it. So I think the one that's labeled DF 241376 that says pay record, I believe that's for Salcedo. Yeah,
That's for the 4-1.
yes. You ready, Joy?
I'm ready. Are you connected?
Yeah. What? Type something. I'll disconnect and reconnect again. Okay, I'll see you. All right. We're on the record and calls number DF 24137763. Councils, will you please announce for the record?
Matthew Creek, I'm here for Sarah Fox and the Fifth Amendment.
Thank you.
Attorney Jane Ball, Assistant Public Defender, Florida, appointed to represent Eastern Palo as involved with the errors.
Thank you. Will those who intend to testify, please stand and raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth? Thank you. You may lower your hands. We are here today on the second amended motion for enforcement that's been on file with the court since February 13, 2026, brought by the mother in this case. Is that correct? And it's the court's understanding that it involves a passport of the child?
That's correct.
Okay. All right. So you all will have 15 minutes aside that will include any opening and closing statements should you all choose to make them, as well as any examination. Prior to going on the record, there were some exhibits that were pre-admitted and they will be admitted at this time. So Mother's Exhibits 1 through 9, it's combined into one exhibit. So we're actually going to label Mother's Exhibits 1, although there are 9 exhibits contained within the attachment, and Father's Exhibits 1 through 3. Right, Attorney Creek, at this time, would you like to make an opening statement?
No, Judge, would you like to have the binder with the exhibits if we?
No, thank you. I have them digital.
I'll just make a brief opening.
Okay.
Can she sit down?
Yes, your clients may sit down.
I'll just make a brief opening, Judge.
Judge, before we get started.
Yes.
I actually filed a motion for special exceptions.
Okay.
Regarding the passport provision and.
Hold on one second. Do you have a copy, a physical copy of it? Because I don't see it on the computer.
I have one copy.
Oh, you combined it in your answer.
Yeah, yes, it's the answer motion for special exceptions, and motion to dismiss. So it's essentially my client's defense to the actual order that they're seeking to enforce.
Okay,
It is his position that the provision that sought to be enforced is not enforceable. So before they move forward on their trial to find him in contempt for the order, I would like to put to the court that the order is actually unenforceable.
okay, you may proceed with your special exceptions.
I understand all the time.
Yeah, it's whatever you want to do. You can sit down if you're more comfortable.
All right, Judge, so. May I begin?
Yes.
Okay. So I asked the court to take judicial notice of the second amended motion for enforcement of possession and access, which was filed on February 13th, 2026.
The court takes judicial notice of that order of, excuse me, that motion, as well as the current order and all contents of the court's file.
Okay, so on the third page of that motion, it shows that Ms. Jimenez is seeking to find my client, Mr. Gutierrez, in contempt for essentially not signing the passport provision, or not signing a passport so that the child would travel. And her alleged violations regarding passport provisions are they are A through E of her motion. And the order that she's seeking to enforce was signed October 13th, 2025. I asked the court to take judicial notice of that order.
I already did.
Okay, and on page 9 of that order is the actual provision that she's seeking to enforce. And I'll read that provision. The paragraph, it says that it is ordered that if either party apply for a new or renewal passport for the child, that party shall notify the other party of the fact no later than 10 days after the application. It is further ordered that if a parent's consent is required for the issuance of a new or renewal passport, that parent shall provide that consent in writing no later than 10 days after receipt of those consent documents, unless the parent has good cause for withholding that consent. And it's my client's position that unless the parent has good cause for withholding that consent, that provision makes the whole passport provision unenforceable. First, I'll say that it gives him the right to say that I'm agreeing to not sign the passport. So it gives him an out. Not only that, the part that makes it unenforceable is that it says, unless the parent has good cause. Now, good cause, that's discretionary. What he thinks is good cause and what mom and her attorney thinks is good cause for withholding him signing a passport, those could be two different things. And the fact that that's discretionary, that's subjective, is up to either party. Either party could say whether or not he has good cause. This order doesn't say what would make his good cause good cause. And in addition to that, I would also argue that if a court has to determine whether or not his cause was actually good cause, that also makes the enforcement, that also makes the order unenforceable. And I'll just read case law, Judge. I have this is Father's Exhibit C. This is Slaveman, which is probably the most important case law regarding enforcement of orders. And Slavin says that Texas decisions hold that an order of a court such as an injunction decree must be as definite, clear, and precise as possible. And when practicable, it should inform the defendant of the acts he is restrained from doing, without calling on him for inferences or conclusions about which persons might well differ, and without leaving anything for further hearing. Again, there shouldn't be any component of an order that two people might differ. And again, this order talks about good cause. If he has good cause to withhold his signature, he doesn't have to sign. That's what the order says. But again, good cause, what his good cause is and what mom's good cause is, those can be two totally different things. So that's why I would argue that that provision is not enforceable. And Slavin also goes on to say that without leaving anything for further hearing. So if there's to be a hearing today to decide whether or not his reason for actually not signing the order, whether or not that was actually a good reason, that also points out the opinion that the order isn't enforceable. So my client is asking that the court finds that the passport provision that says that he's supposed to sign within 10 days unless he has good cause not to. He's arguing that since the order contains an out, but that out itself is not enforceable. He's asking that the order is determined to be unenforceable and that mom can't proceed on her motion for enforcement to find him in contempt for an unenforceable order.
Thank you, counsel. Response?
Yes, Your Honor. Judge, this language is straight out of the Texas Family Law Practice Manual, which is the standard that is used in family law. That's in orders. Mr. Gutierrez had a couple chances, one with the MSA and a second time when he read the final order to decide, I don't think this is clear enough. I don't know, I'm not sure about this. He signed it, he agreed to it. He filed a response with the court, obviously, where he understood exactly what was going on and explained it in great detail. There wasn't anything left to debate or argue about. But this is standard. There's nothing unusual about this. Sometimes people disagree, but if you're going to hold this enforceable, then any person can come in being asked to be held in contempt and say, well, I just didn't understand. It's not enforceable because it's not clear enough for me. The only alternative to fix it would be list out every single possible thing that would be good cause or not good cause, and that's just not appropriate. Sometimes you do have to have the judge decide, well, does the party have good cause or not have good cause? And I believe there's plenty of case law that probably outlines that, what is good cause. And there's been some different cases that talk about, well, does the country follow the hate convention or anything like that? That is a parent, a flight risk that might not abduct the child, not bring them back. But just to say, just because something seems unenforceable, it's going to lead down a road where does a Texas Family Law Practice Manual not matter at all anymore? Does that language not matter when we put it in there? That's all, Judge.
Hey.
Judge, am I able to respond to that?
Yes, go ahead.
Judge, I don't believe that. The Texas, the practice manual is meant to be a guide. Just because it's in a manual, that doesn't make it enforceable. And I think that probably the proper venue for this issue, or the proper motion is probably a motion to compel. You are asking for him to be found in contempt and to be given a jail sentence for an order that's not enforceable. It's not about whether or not using the manual is whether or not that's the standard or not. And it's not about the issue isn't so much he signed it and he agreed to it. That doesn't make the order enforceable. If it's not clear what he was supposed to do, and if two people can disagree in terms of what the order means,
that makes it unenforceable. And you don't give someone a jail sentence with an with an unenforceable order. Again, I think this is also a motion to compel to go before a judge, and then y'all can talk about whether or not his good cause was good cause. But it's not appropriate when there's two different opinions about an issue and you're asking for an out of jail sentence.
The court doesn't believe that jail would be proper in this type of situation anyway. However, the court does need to hear what the good cause is for withholding. I mean, that's what the order says. So I have to follow and enforce, and I have to follow it as is written. So the special exception is denied. Counsel, you may call your first witness.
Judge, I have a question about what you said. So.
Go
you said
ahead.
that You don't think that, you said, you don't think, I'm trying to understand what we're doing today.
Well, your argument is that the order is unenforceable.
Right.
The court doesn't believe the order is unenforceable. Now, does the court believe that there's some language contained that may be ambiguous? Yes, but the court doesn't believe the order, that portion itself is unenforceable.
Even if there's language that's ambiguous, that doesn't make it unenforceable?
Well, it doesn't make it to where I can't have a hearing on what her allegation would be.
So my question is, and the court said that you don't think that this is an issue of enforcement, so are we having a hearing?
No, I said he's not going to be put in jail for this. That's what I said. Yeah. Yeah, you're welcome. Counsel, you may call your first witness.
Just kind of clarify, what did that take away from our minutes, just for?
No, I didn't charge either one of you for time on that one. No.
I'm calling Maria in this.
Okay. Ma'am, you may have a seat right here. Just make sure you pull the microphone close to your mouth.
Let me know when you're ready.
I'm ready.
Okay,
You may proceed.
thank you, Rhonda. State and spell your name for the record.
Miriam Jimenez,
Can you spell
Miriam, Jimenez, Jimenez,
Okay. And what's your child's name?
Chloe Jimenez Gutierrez,
And how old is Chloe?
she's 7,
And is Pablo her father?
yes,
Okay. And you and Pablo reached a mediated settlement back in September 2025.
yes,
And was that MSA filed with the court?
yes,
And then after that, you guys get the final word. Contract to the relevant.
Yes.
On the MSA, Judge.
What's the relevance?
Relevance is just that there was an MSA and the final order was based on the MSA.
So is that just background?
Yes.
Okay, overrule.
And as part of that final order, where there's some basic passport provisions for renewing Chloe's passport.
yes.
And when did Chloe's passport expire?
I believe it was April 2024.
Okay. And as part of that final order, did you have to ask for Mr. Gutierrez's consent to renew the passport?
Yes,
Okay. And did you do that?
yes,
And was that through, how did you do that? Was it through Pat Close or Our Family Wizard or?
we're up close.
And what day did you ask for his consent?
I believe it was November 30th. 2025.
November, kind of get you to look at exhibit number M2. Can you look and see what day you asked him?
It says November 20th.
And did you offer to go in person to renew Chloe's passport
Yes,
and with Pablo?
yes,
Okay. And did he respond?
yes.
And what did he say?
He said no.
Okay. And is that when you sent him the passport form, the consent form?
Yes,
And then, did he agree at that point?
No,
Did he give you a good reason why he didn't agree?
no,
And did 10 days pass without Pablo providing his consent?
yes,
And when was that deadline?
I believe within 10 days after I asked.
Around December 1st.
Yes,
And has he consented as of today?
no,
Why did you want to renew Chloe's passport?
I wanna be able to travel with her during holidays, and now because of the eyes situation, just to have extra documents for her.
Okay, and let me go back. You said because of the eyes, are you talking about you might have extra documentation that she's a citizen just to protect her?
Yes,
Um. Were you considering visiting Mexico for Christmas?
yes,
Okay, but did you tell him that's where you were going?
no,
And who lives there in Mexico?
my family
Who's your family?
and, uncles, cousins,
Did your grandmother live there at that time?
she lived there at that time, she passed, January, beginning of January.
Right, and because Pablo refused to sign it, did she pass away without Chloe getting to see her?
Yes,
And was Chloe able to go to the funeral?
no,
Did Chloe love her family down there?
yes,
When she wants to go out of town, where does she say she wants to go?
where her family is from,
Okay, has she been there many times?
yes,
How many?
I would say 8 or 9 times,
Has she been there recently?
no,
When was the last time she went?
last January,
Okay, and so, and Pablo was aware of that.
no,
Has he been aware of any time you've gone down there
yes,
while you were together? I don't object to speculation, what he's aware of.
Sustain. Rephrase.
While you two were married, did you ever tell him you were going to Mexico?
when we were together and not together, he was always aware.
Um. And before you were going to, if you had decided to go to Mexico, would you have given him all the required, the itinerary and all that that's required under the order?
Yes,
Um. If you were to go down there and your family thought it was unsafe, would they tell you?
yes,
Have they told you?
I
Hey,
don't object to speculation,
Judge, she would know if her family has told her before.
so she can't hassle what people.
Well, the question was, if you were to go down there and your family thought it was unsafe, would they tell you? Overrule, I'll allow it. So if you were to go down there and your family thought it was unsafe, would they tell you?
yes, Your Honor,
And your family loves Chloe,
yes,
loves you,
yes,
doesn't want you to be in harm's way.
yes,
Is that, are you just asking the judge today to force him to sign the passport and to hold him accountable for causing Chloe to miss her grandmother's funeral and not see her grandmother at Christmas?
yes,
After this happened, were there a couple incidents with the exchanges?
yes.
What happened?
He has withheld Chloe, refuses to let her go out of the car. Where there's been times I had to call the police.
How many times did that happen?
I believe it was 2 occasions.
And why do you feel like you need to call the police?
If I felt unsafe just because he was also using profanity while he was talking to me.
So y'all were there to exchange and he just didn't hand Chloe over?
No, he didn't let her out the car as well.
So do you feel like he did that as part of you bringing the suit?
Yes,
Absolutely, Your Honor.
All right, Cross.
Thank you, Judge. Alright, so Ms. Jimenez, you stated that the purpose of the passport and the purpose of your intended travel, when your attorney asked you, you said you didn't tell Mr. Gutierrez the purpose of that trip and the purpose of the passport, is that correct?
Yes,
Great. That my first witness?
Yes.
I'm showing you what's marked as Father's Exhibit 2. Can you read that first line for me, please?
it says, it is ordered that the child shall not leave the United States without a proper passport and prior notification and missionary information provided to the other party and as more fully set forth below.
And that word is itinerary. Do you understand what itinerary means?
Not really.
All right, you know what it means. So an itinerary is your schedule of what's happening, where you're going, where you're gonna be on this date, time. You understand it that way?
I do now.
Okay. So do you understand that this order says that before the child is to leave the United States, you should have a passport and you should give notification of where you're gonna go with the child. You understand that? Yeah, you're supposed to give that notice to the father. You understand?
Yes,
You understand that now?
yes.
Did you understand that previously when you were asking him to sign a passport?
I don't believe.
Right. Well, regardless whether or not you understood it, you didn't tell him where you were going with the child, is that correct? Because that's what you
Yes.
just told your attorney, okay. So without telling him where you're going, you wanted him, without telling him where you're going with the child, you asked him to sign a passport to travel with the child, is that correct?
Yes,
Okay. Isn't it correct that you mentioned the ICE situation, you talking about the immigration tactics that's being used by the current administration, is that correct?
yes,
Isn't it correct that all three of you all are US citizens, you, Mr. Gutierrez, and the child?
yes.
Correct. But I understand even with that, that's still a concern, right?
Yes.
Okay. Would that be a reason for him to not sign a passport?
Can you ask me again?
That's what's there. Isn't it correct that he actually provided his reason why he wouldn't agree with the child? He provided his reason why he didn't sign a passport, is that correct?
Yes,
Okay, and he actually filed that with the court, is that correct?
yes.
Do you remember what day he filed it?
No,
Okay. I'll pass it with you, Judge.
All right, anything further? Redirect?
Just briefly, Your Honor. Miriam, when you asked him to sign the passport, were you absolutely certain where you were going?
no,
Is that why in here you said you were planning ahead for a possible vacation?
yes,
Okay, and you, are those two separate things to you? Renewing a passport and then deciding where to go?
yes,
So if you didn't have a trip planned for a year, you could still renew the passport. And then decide to plan a trip a year later, right?
yes,
That's it.
All right,
Didn't you just say that it was your intention to go to Mexico to see your family?
yes.
Good, so you're saying that so why is your answer different when he asked you this?
It was something that I was planning on doing, but I couldn't do it without having that passport signed.
Right, I understand that, but when you were trying to get a passport, the purpose was for you, again, you asked November 20th, right?
Yes,
And
you were planning for Christmas, is that correct? That was your testimony, I believe.
Yes,
Okay, and you were planning to go to Mexico for Christmas, is that correct?
yes.
Okay, so you knew where you were going. I'll pass the witness, Judge.
All right,
Further questions, Your Honor?
okay, ma'am, you may return to your seat. Counsel, you may call your next witness.
That's wrong.
Okay. Attorney Powell?
To Your Honor. Can I call myself as a witness? That time.
Yeah, you have time. Counsel, he's gonna call himself as a witness.
Can you tell me how much time I have left?
7 minutes and 43 seconds left, and Attorney Powell, you have 10 minutes and 25 seconds left.
Just a moment, Your Honor. Can I proceed, Your Honor?
Yes.
Your Honor, my name is Matthew Creek. I've been licensed practice law in the state of Texas since October 2022. I was prosecutor at Collin and Dallas County DA's office, where I held the positions of misdemeanor chief prosecutor and felony prosecutor. I worked in private practice for about 1.5 years and have practiced family law for right at a year now. I'm directly supervised by Ms. Sarah Fox, who's board certified in criminal law and has been practicing family law for almost 7 years. It was necessary for Ms. Jimenez to employ the Fox firm for this case, and Ms. Jimenez agreed to pay the following compensation. I bill at $3.50 an hour, our paralegal is $200 an hour, and Ms. Fox bills at $4.50 an hour. I'm familiar with the customary and reasonable fees charged in this county for the legal services in cases involving issues that are before this court. The attorney's fees Ms. Jimenez has incurred so far, the results of this suit are roughly $7,837.50, plus about 2.5 hours a day, which equals $875. These are customary fees charged for the same or similar legal services for an attorney in this county with my ability, expertise, and reputation. So we would be asking for $8,712.50 in attorney's fees, Your Honor. I'll pass the witness.
Thank you. Any questions, Attorney Powell?
You said that you've been licensed since October 22.
Correct.
Attorney Powell, could you bring that microphone to your mouth?
I apologize, Judge.
It's okay. I know you speak very low.
Are you aware that I sent an offer to Attorney Sarah Fox to settle this without coming to court today?
I am aware.
Okay. And you saying that you've accumulated $8,000 in fees regarding just this issue?
That's correct.
Okay.
Those were sent to you in our exhibits.
I'll pass the witness, Judge.
Okay,
Nothing further, Your Honor.
all right,
We rest at this point.
okay. Attorney Powell, you may.
Judge. I'll call my client.
Okay. Just pull the microphone close to your mouth. Whenever you're, oh, yes, yes. Whenever you're ready, counsel.
Mr. Gutierrez, you state your full name for me?
Osvaldo Gutierrez.
And you're the father of Chloe Gutierrez?
Yes.
Okay. And you understand that we are here today regarding the passport provision?
Understood.
Okay. And what's your understanding of the passport provision and what rights it gives you?
According to the contract that we signed, that I read over and over, tells me that I have my options to deny, and I gave my reasons.
Okay. And you filed your reason with the court, is that correct?
Yes,
And you heard mom testify that I believe she began a process of you signing that on November 20th, is that correct?
repeat again?
You heard mom testify that she presented you with a copy of the passport to sign on November 20th, 2025?
No text message on.
Okay. Judge, may I approach the witness?
Yes.
And Mr. Gutierrez, you also. I will draw a question. You take a look at that. And what is that?
Well, what I found,
And what did you file?
well, the reasons why I denied the passport.
Okay, and so you just didn't, I mean, have it back? You just, and Judge, I guess it's already admitted, but I'm having them look at Father's Exhibit 1. So, Mr. Gutierrez, so you just didn't ignore the fact that she was asking for you to sign a passport, is that correct?
No,
You actually, you filed a 2-page notarized statement as to why you disagree with signing the passport, is that correct?
yes,
And can you tell the court why you disagree with signing a passport?
Ms. Jimenez has spoken to me within time that she's not trustworthy and no communication from her side. And false accusations that she done last courts to me.
Good. What concerns did you have regarding the child? Well, what, in terms of what you put in the statement regarding where you believe mom would go with the child, what concern did you have with that?
The moment she takes off to Mexico, I would have no advantage to see my daughter or speak to my daughter. Or if she's in good condition, I would have no whatsoever contact with her over there. And the moment she goes to Mexico, I know she will disappear with my daughter for the amount of vacations that she has. But within that
I'm sorry,
time,
what did you say, malifications?
Due to the, she has rights to travel, so I say, for the amount that she'd be on vacation, I would have no contact with my child. Or if I know she's in good health, I would not know nothing.
Okay, and you and I discussed this issue also, is that correct?
Yes,
I mean, we discussed it in preparation of the case and preparation of making a settlement offer, is that correct?
yes,
Okay. You also told me of an incident that Ms. Jimenez told you that happened previously when she went to Mexico with the child, is that correct?
yes.
And what was that?
The Menace works in a thrift store where she deals with a lot of donation stuff. So she travels to Mexico with a lot of things. And this one, our daughter was barely a year.
Yeah, okay, Your Honor, just before the last order, it's temporally relevant.
Sustain.
Well, Judge, it is relevant if this is reason for why he didn't sign the passport.
Before the order?
No, it may be an event that happened before, but that's his reason for not signing it, and that's the reason why we're here today. So even though it's something that happened, it's still his reason, like his thought of, no, I don't like that, is for something that happened prior to the order, but like we're not litigating something that happened prior to the order. It's just his thought of why he has a problem signing the document, that's why
And how old is the child now?
how old is she?
7.
He said she was 1.
Right, I understand, but can I at least have him testify and he could say whether or not that situation could still be present today?
He can say that a situation happened before the order, but he can't go into detail about it because it wouldn't be relevant today. It's 6 years old.
But it's relevant because it's when she's asking him to sign a document, that thought is in his mind at that time. I mean, we're not modifying the prior order. He's trying to enforce an order. He's trying to, well.
That's a stretch, counsel. That's a stretch. You want the court to consider something that's 6 years old that predates the current order.
Well, can you listen to the testimony?
I can listen that he has distrust for her in terms of something she's done in the past, but something that is 6 years old for in terms of the details of it is not relevant.
Well, I'm not asking you to consider, I'm not asking you to consider the incident. I'm asking you to consider him thinking about the incident, and that's his reason for not agreeing to sign the document.
Right, we're saying the same thing. I'm just saying I don't need to know the details because the details aren't relevant to me. Now, as far as him, an incident occurring and him feeling a certain way, then that's another thing. Although the court is aware that it's 6 years old.
But it's an incident that would contribute to his good cause for not signing. And he's saying that I'm concerned about that because that situation probably still exists today.
If it's something that is ongoing, then I would rather hear that than something that's 6 years old.
Okay. Okay. All right. What? So. So what is the thought that you had that,
Well,
that additional thought that you had that made you concerned about signing a passport provision?
the thought that I have that she still does to this moment, she travels to Mexico with a lot of things. And she travels with a truck full of loaded things, and that right there drives red flags over there. You get pulled over by police, you don't cost them more money, get everything taken away. You get pulled over by the cartels, ask you why you're so loaded. That's my concern. She still works in the thrift store. She still travels with a lot of materials to Mexico. That is very concerning. And when you go in a truck, you're even screaming more loud to be robbed.
Okay.
So that's my concern.
Okay. And so
And it
she,
still exists.
right, and she told you about something that, she told you about an incident where that actually happened, is that correct?
Yeah, in the past.
Right, and that happened 6 years ago, correct?
Yes.
But it's your fear that that could happen today.
Again, because she still works in that store, still travels with a lot of materials to Mexico.
Okay, thank you. And so, and you added that to your good cause reason as why you didn't agree with signing the document.
Yes.
Okay. And I'm not, okay, okay, and again, you gave your reason why you didn't sign the document, is that correct?
Yes.
Which is what the court order gives you the right to do, correct?
Yes.
It gives you the right to withhold signing a document if you have good cause, is that correct?
Yes.
And you believe, based on what you told the court, that that's your good cause reason for not signing a passport?
Yes.
Okay. And you would have safety concerns for your child traveling to Mexico?
Yes, I do.
Okay. I'll pass it with instruction.
All right. Cross.
Yes, Your Honor. You agree that before when you refused to give her consent, she did not tell you that she was going to Mexico, correct?
She never told me nothing.
So you were just purely speculating that's where she was going.
Well, she always runs to Mexico. Due to those.
You didn't know where she was going, correct?
History that we have, she runs to Mexico.
I'm just gonna ask you if I say to answer yes or no, because I'm short on time, okay? You agree that if she went on a cruise, you wouldn't know if your daughter was okay, correct?
Correct.
You wouldn't be able to talk to her if she went on a cruise, most likely, correct?
Correct.
You wouldn't be able to go out and make sure she was safe because she's in the middle of the ocean, correct?
Correct.
And all those same things apply if she went to Mexico, according to you, correct?
No. She would, in Mexico, at least she would have seen, but she chooses not to communicate.
So it's okay for her to go on a cruise to in the middle of the ocean and not communicate, just not go to Mexico to see her family.
If she would have communicated from the beginning, we all would have able to do this.
When she first asked you to sign the consent form, did you write back and say, hey, here's some things that would make me feel comfortable to make sure this can happen?
I just sit there on a list to tell her,
Did you
if we
bring
work
that
on
with you?
these, if we work on these conditions, then we can look for a better future for our daughter.
Did you bring that with you? Because I didn't see it in your exhibits.
I'm object irrelevant, Judge.
He's talking about evidence.
Overrule, I'll allow it.
You didn't bring that with you. Is that
Well,
correct?
Judge, I'm objecting.
Evidence
because-
on
Hold on one second, sir. Hold on. Go ahead with your objection,
I'm gonna
counsel.
object that would be a settlement offer. If she asks him to sign a document and let's just hypothetically say I was signing under these conditions, that's them making, that's settlement. So I object. to that as a
Sustain.
settlement offer.
You agree that, Chloe's went to Mexico before, correct?
without my knowledge, yeah,
She's gone with your knowledge, correct?
not without my knowledge.
You agree that she's not required to, while she's on vacation, keep up and communicate with you the whole time, correct?
That's what it says on the contract.
You think it's in Chloe's best interest to be able to see her family in Mexico?
They can also come over.
You think was in her best interest to go to her grandma's funeral?
This human has never told me nothing about that. So I was not aware of the
You
situation.
would have agreed you would have agreed to sign it if it was for the funeral?
And the client would have negotiated with me.
Hold on one second. What was your objection, counsel?
Settlement.
Sustain.
In 6 years, you testified earlier that she's gone to Mexico, according to you, many times carrying a bunch of stuff for the thrift store, correct?
Yes,
And in 6 years, has she ever been, mugged, anything like that, to your knowledge?
Mark,
Hold on, that's a yes or no. That's a yes or no. In 6 years, has she ever been mugged or anything like that to your knowledge?
to my knowledge, I don't.
Has she ever called you and said, hey, there's a police report, this happened? Anything to make you think that she had been in danger?
My daughter got sick and she never called me, so she doesn't communicate.
I'm just gonna pass the message from there.
Okay.
Alright, briefly, so you understand that mom is asking that you pay her attorney fees in the range of $8,000?
I already have 2 attorney fees and I'm struggling.
Objection, not response. Well,
Sustain.
alright. My question is just, you understand that she's asking that you pay $8,000 in attorney fees for this action?
Yes,
And is it your position that you did what the order gave you the right to do?
I follow the rules.
You gave your good cause reason for not signing the order, is that correct?
Yes,
Whether or not mom agrees with your good cause reason, you provided your good cause reason, is that correct?
yes,
Right, and I'm assuming the court today is gonna determine whether or not you sign a passport. But you understand that you did what the order gave you the right to do,
yes.
okay? And, okay. Well, when mom's attorney asked if mom previously told you that she had been mugged before. But didn't you say that mom had previously been stopped and had to pay money to keep moving? She had to pay money to strangers so that she can proceed with her trip?
Yes,
And so that's not necessarily a mugging, but I mean, I guess that would be.
pretty much like border patrol,
Okay.
they don't pay up. But we take everything.
But was it border patrol or was it something else?
People,
So
gang members,
gang members, hold, and your child was present for that?
yes,
Okay, and so that's your reason for having a hard time signing this document?
yes.
I'll pass the witness, Judge.
Thank you. Counsel, you have 38 seconds left. Did you have any other questions?
Just one or two.
Okay, go ahead.
You agree that millions of people go to Mexico every year,
People travel, yes,
okay? And millions of people take their kids to Mexico, correct?
and what kind of mean, because we're not together.
No, millions of people just obviously people cross the border, millions of people cross the border every year, correct? So the only person you don't want to cross the border is your daughter and your ex-wife. to see their family.
Like I said, we missing minutes does not communicate, and she has shown me signs that she doesn't want to talk about simple things.
She did communicate, you agree?
Now, her communication is demanding, not communication.
No further question, Your Honor.
Okay. All right. Anything further?
Briefly, when you say mom didn't communicate, she didn't tell you where she was going with the child.
No, she was just demanding for me to sign papers, and using lawyers behind her, wait, behind her shoulders.
I'll pass away, sir.
Okay.
That's the problem.
Sir, you may return to your seat. I have a question, sir. Is it just Mexico or is it anywhere outside of the country?
Get better, both travel. I just want our standing because she's aware that her child knows that we're not talking. She's already trying to take advantage of it.
Well, I wouldn't just say that she's doing it. I think both of you are equally responsible for that.
I said, Ms. Jimenez has been lying a lot, no communication. Constantly have to find my third party about my child. If Ms. Jimenez was actually takes the time to talk and show any kind of talkness between each other, we wouldn't have not been here. We would have came to mutual ground.
Hold on one second. Hold that thought. Did you tell him about your grandmother passing away?
No.
Why not? Yeah, but you understand what he's saying though, right? Hold on one second. Yes, you may take your seat. If he's unaware, he can't act. So if it was your intention to make sure, because I don't think anybody in this room would want a child to miss a funeral of a family member. I don't think anyone would want to do that. I'm a parent and I wouldn't want that to happen. However, at the same time, if he doesn't know and you didn't tell him, he can't agree for his child to go across the border if that's not something that he's aware of, especially since he's harboring feelings of things that you've done to him in the past. You understand that, right? From the court standpoint, the order is parts of the order is unenforceable, right? And that's going to be your issue because in one part, Attorney Powell, it was a great question, but it's not here. It says that first line, it is ordered on page 9, it says, it is ordered that the child not leave the United States without a proper passport and prior notification and itinerary information provided to the other party as more fully set forth below. It doesn't actually say that the notification and the itinerary has to come first in time. And I believe that was the question that he was asking his client. So that's going to be one of the first issues. It's ambiguous on that portion. And then you didn't tell him necessarily where you were going. From where I'm sitting, the issue that both of you are having, and this comes up a lot in enforcement actions, is lack of communication. You have to talk to him, especially with what's going on right now in the world, considering your concerns. That is a legitimate concern. I'm not going to downplay anybody's concerns, right? It's a legitimate concern and you have to communicate about that. On the same end, if you decide you want to take the child out of the country and she says, no, you all are going to be in the same position, the court is not the place for it. Not for a disagreement like that. You should want your child to see the world. However, you have to communicate and you have to talk about what is going to happen. I think this order needs to be modified before it can really be enforced the way that you will want to do it. I would encourage you, though, to talk. She hasn't had a passport since April of 2024. I'm sure there are other places outside of Mexico both of you would like to take her, right? So y'all are both here. The passport office is downstairs. Y'all can grab an application, talk about it, and get it signed. Because in the event you want to take her out of town, or out of the country, if her passport isn't renewed, you're further delaying it. That doesn't make any sense. Don't wait until either one of you want to decide to take her somewhere, but then you can't really do it because the passport isn't renewed. Here's the deal. She can't take the kid out of the country without you knowing anything anyway. He can't take the kid out of the country without you knowing anything anyway. Either one of you remove the child with the passport without the consent of the other parent, you have bigger issues than this court. You know that, right? So the court has to deny the motion for enforcement. And I would encourage you all to talk for your child's sake. I mean, she's 7. Where are some places you want to take her?
Hawaii.
Hawaii. You don't necessarily need a passport for Hawaii, but let's see. Where is somewhere else you want to take her that's out of the country where a passport will be required?
Tokyo.
Tokyo. You need a passport for Tokyo. When you want your daughter to experience Tokyo, you need the passport. Outside of Mexico, is there anywhere else you would like to take her? I heard your counsel say a cruise. If you go on a cruise, I've never been on a cruise. I have no interest, by the way. But it's my understanding that when you dock and you go certain places, you have to have your passport, right? Don't you want your daughter to go on a cruise? I want her to go on a cruise so she can tell me about it because, like I said, I'm not going. So you guys need to work together. Like I said, while you're here, grab an application, talk through it. You already know ahead of time what the two of you want to do. Tokyo and a cruise. That's a starting point. Talk about when y'all gonna make that happen. But in the meantime, this order needs to be modified. Okay?
Just for clarification, are you saying that Mexico would be off the table? Because a lot of cruises go to Mexico.
No, I'm not saying Mexico would be off the table. What I'm saying is that if the two of them communicate more, well, let me back up. Dad's concerns, I didn't think that they were illegitimate. I believe he raised legitimate concerns. However, I think that those concerns, had you all communicated a little better, I don't think you all would be here today. The lack of communication causes people not to trust the other person. You're always, especially when there's a history, something has gone on, like he said something 6 years ago, to someone else, it's like, oh, that's not a big deal. But to him, that may be everything. Same thing for her. It may be everything. And that's what's causing the friction, right? So you all have to communicate. You have to work through whatever has happened. You may have to do some assurances to him that what has happened in the past will not happen moving forward because he's still holding on to it. And the same thing goes on your side, right? If there's some assurances you need to make over here for her to get past whatever it is that she's hung up on, y'all are going to have to do it. Because if you don't, your daughter is going to end up suffering. And her knowing that the two of you don't speak is even worse. Because kids are smart, they will play parents against each other. And you don't want to do that because at the point that a child starts doing that, neither one of you have control over that kid. So while you're here, at least see what you all can discuss and come up with. Otherwise, she's never going to go anywhere. And that's not fair. Okay.
Ask one more clarifying question.
Sure.
I just want to make sure I understand if, I mean, obviously they're divorced and they've had a hard time communicating in the past and working these things out. That's why we wanted the final order that we thought was clarifying how that guy. But assume they try to talk, and I believe they have done that in the past and it hasn't worked. But if they try to talk and there's still no resolution, what is your suggestion for us solving these issues?
Well, and I can't clarify this order without making substantive changes to it, which isn't allowed by case law. However, the two of you can make any agreements that you want to modify the order. Absent an agreement, you have to file a modification and get it heard that way. I hope after talking to me, you guys have something that you can potentially work out. Not saying that it's just a miracle, but I do think getting in front of a judge makes a difference in hearing it from me. So maybe that means something, maybe not. It's just worth a shot. I like to put that out there. All right. You all have any questions before you leave?
None from us, Your Honor.
Okay.
Thank you.
Yes. You have any questions?
No.
Ma'am, do you have any questions? Okay. Thank you all. All right, Attorney Powell, you're on the next case. And Attorney Sweet is here. Hi, Attorney Sweet.
Hello, Your Honor.
Welcome.
Can I have 1 second?
Yes, Attorney Sweet, say something. I couldn't hear you.
Yes, Your Honor.
Oops, I can't hear you.
Uh-oh. Your Honor, is that a little better?
Still can't hear you. I know you're saying something.
You're able to hear me?
Oh. Yeah, she probably has to log off and come back on. So y'all don't have an agreement?
I think we need a minute, Judge. I'm sorry.
Okay.
It's gonna be raised another issue.
Okay.
So Judge, we have 3 open cases. The child support enforcement, Mr. Saucedo filed an enforcement of possession and access, and then they've got counter petitions for modifications.
Okay.
What we're doing is solving all of those today. And so we do need to talk about that passport provision that we're talking about here, just to make sure that it's enforceable. Because we literally referenced the Texas Family Law Practice Manual language, which is exactly what was at issue just now.
Okay. That's good that you all sit in here so you can see it for yourself. Yeah.
Judge, this young lady was sent up here for a name change issue. I didn't know if you wanted to talk with her.
Hi, sure. Come on up. I didn't even see you back there. He'll grab it from me. Okay. Thank you. Okay, so you just filed this today. So what you'll have to do is your original fingerprints, you have to send it to DPS. Yeah, so send it in to Texas Department of DPS. Now, how you do that, I'm not exactly sure, but if you will contact DPS, they will be able to tell you how to do it, or you can even go into one of the local offices and they'll tell you how to do it. Once you submit the fingerprints to them, DPS will then send something to us and we'll have it on the computer. So we'll see that the background check has been done. Yeah, so you have one more step. Yeah. No, so what you'll do is, and this is actually good that you came here today, so you'll never have to come in person again. Yeah, that'll save you some time. So after, do you have access to the online site to see the activity going on in your case? There is, let me see if it's still the same. So you can create an account. You have to, why is my screen moving? Now you do have to put a card on file, but as long as you're filing a no-fee document, you shouldn't be charged anything. E-file. Texas.
So would I need to file it, or that's just where I go to check?
To check the status. So you've already filed the petition and everything. So once you create your account and put your case number in there, everything that you file will be on there. Now, what you do need to e-file is your order of name change. You can go ahead and file that, although you still have to send your fingerprints in. Tyler.
To get official documents of the name change, do I come back here, or is that something I can do?
Oh, no. So this order that you're going to e-file, once you e-file it and you have the name in there, we'll change it to it. Yeah. Once everything is done. So this is the website. Here, I'll give all this back to you. So let me walk you through it. So the first thing you want to do is you can go to on your iPhone, you can do it from a laptop computer, desktop computer, type in this this website here, and you'll see register. Let me put that on here. You'll click that register button and you'll get you a new account. Like I said, you'll put a credit card on file. As long as there are no fees attached to the document, it'll be free. So then that way you put your case number in, you'll be able to file right into the case. So now that your application is on file, you're going to contact DPS, whether you go in person or call them over the phone, ask them about sending your fingerprints in. After they have ran the background check, according to your fingerprints, they'll send a document to us and put it on the computer. You can check to see if that document is up yet. But in the meantime, go ahead and file your order. So then when you see the document has been returned with your criminal history, you can email my coordinator, Brittany. Have you emailed her before? Okay, I'm gonna give you her card. You email her and ask that you be put on the submission docket. And submission dockets occur on Monday. So submission, that means you don't have to log on to Zoom, you don't have to come down to the courthouse, anything like that. Like I said, if everything is correct, the order that you e-filed, we will go ahead and sign it on that day.
Okay.
All right. Now, if something is missing, my coordinator will email you back and letting you know what's missing, which they will still need. Okay. All right.
So
Yes.
just to clarify.
Go ahead.
I look at the file status to see if the background check has come back. Once it has, I email for
The coordinator,
your coordinator,
Brittany.
Brittany.
Yeah.
And then from there, you guys will do the work. If there's anything wrong, you'll email me. Okay.
Yep.
Sounds good. And then for like documents to change social security and all of that stuff, do I need to come in person to grab a copy? The name change?
So you could think there's a way isn't there a way that they do certified copies online now since COVID?
I have not been able to do that, Judge. I always have to come here to the records building.
You know what?
Come up here and you can start.
Ask anyway.
Okay.
Because I know in probate court, people were requesting documents be certified and they were able to get them certified some way through email. Well, while you're here on the first floor, that's where the clerk's office is. Did you get a stamp down there?
Yes.
Ask them, because if there is a way to do that, then you can pay for it that way. But if not, you can come back up here and get a certified copy of the order. If I were you, I would get like 3 copies. So you can make sure that you take it to those offices and get everything changed that you would need. Okay, you're welcome. You have any other questions before you leave? Okay. You're welcome. Have a good day. Thank you. All right, Attorney Sweet.
Yes, Your Honor, are you able to hear me?
Oh, I can't hear you.
One more time.
Okay.
We got another name change.
Let me see. How are you?
We're supposed to send them to the clerks.
Yeah.
Next time, send them that way. Yeah.
Okay.
I went down here to 255, but I guess no one was in there.
Oh, you're talking about just Miss, Jean?
Judge Lee.
Judge Lee?
Oh, yeah. Yes, ma'am.
Okay, is that where I'm supposed to go?
So it's probably online. If you, did you get
I just filed it today.
oh, okay. Yeah, so it'll be the same thing as what I just explained to her. You have to get your fingerprints done by DPS. You've done them already?
I have.
Yes, same exact thing.
So I have to take this to DPS?
Yes,
Right
ma'am.
here?
Yes.
Okay.
So DPS, what they'll do is that once they run your background check with those fingerprints, then they will send the notification to us. That's how we'll know that it's been completed.
Okay, so what do I do with these two copies? The one that you have in your hand and this?
You can hold on to these. Do you need to create that online website too? Okay,
Ma'am.
I'll write it down for you. That's okay. Now let me pull it back up because I don't remember it by heart.
It's not a problem. And you said go to a DPS,
Office, yes, ma'am.
I will be able to.
I don't know it. Yeah, I don't think that's an office.
There.
The closest one, where's the closest office here? I'm not sure here, but if you, yeah, I just know of the one off 20. Yes, right there. That's the only one that I can think of.
Yeah.
And Dunkin' Donuts.
There's a mega center in Garland, right? Off of
There's one, I think
West
it's on
Highway.
the Dunkin' Building, open the one off of, Wheatland and Trent.
Oh, the one off of Wheeling and 20 is still open.
Yeah, well, Wheatland is still open.
Okay, that's it. Okay.
Yeah,
Yeah, that's not Duncanville.
yeah.
Okay, I need to go to the DMV, right?
Yes. So you also need a proposed order. Do you have that too? It'll look like this, but it says order on petition for 19. I just want to make sure you have everything before you leave.
And, this is what I got downstairs. I don't know.
Okay, that's for the prove up. So you'll e-file this too.
When will I e-file that?
You can, oh, you have both. So you'll fill both of them out. And once you create the online account, you can e-file each one of them into your case. Now make sure they're separate documents though. Don't scan them in together. So after you fill both of them out, you need to scan them in individually, because when you click on, you'll see what I mean when you get on the website, you'll have to label them.
I don't have a stamp. Am I able to do it with my phone?
Yeah, you can do it with your phone, or you can, a lot of people go to the library, the public library, and do it.
Okay. It'll take a PDF file, right?
Yes.
Okay, so, when I go to the DMV, which one do I need to give them?
Give them the one with the fingerprints attached, the petition,
The finger,
the
Oh.
petition.
this one right here.
Yes,
Okay. and
yes, they need the original.
Okay, but do I need to fill out this right here and give to them?
No,
just.
they won't need that. That's for us.
Okay, just fill this out and when I create my account.
Yes, ma'am. And you'll go to this website, create your account, and then you'll see where it says register.
Yeah.
You have to put a card on file. As long as there are no documents attached that have fees, you won't be charged anything.
Okay,
And you can e-file each one of those.
okay,
So they'll already be on the computer. Once you complete your turning your fingerprints, DPS will then send us notification of the background check, and you'll email my coordinator and ask to be placed on the submission docket. If everything looks good, we'll go ahead and sign the order.
okay, but if not, I have to come back.
No, you don't ever have to come back down here.
Okay.
That's why I'm giving you this website.
Okay,
Yes.
and how do I get a copy once everything is completed?
As I said to her, if you're not able to request the certified copy online, you have to come back down here to the basement
Okay,
and get like 3 certified copies.
all right, thank you.
You're welcome. Have a good day.
You as well.
Thank you. Okay, let's see. Okay, Attorney Sweet is connecting to audio. Let's see.
Is this working, Your Honor?
No, I still can't hear you.
I don't
I
believe
don't
it's on
know.
Tell her to
my
call my cell
end.
phone.
Can you call Joey's cell phone?
Yes.
Here, I'll drop it in the chat. Hold on. I know your number.
By heart?
Yeah, no, but I know your number.
I got it. I sent it to her.
Okay. It should be in the chat.
469.
And you all can come to the bench. Since it's hybrid, I want to make sure you all can hear her.
Miss Sweet Stephanie? Can you hear me? Stephanie, can you hear? Stephanie, can you hear me? Can you hear me on the phone? Stephanie, can you hear me? Stephanie, can you hear me? Can you hear me? Could it be because I'm on my hotspot? You call her on speakerphone.
Okay.
I'm gonna have Judge call you. 214
Uh-huh.
886.
Hold on. Press the wrong prompt. Uh-huh.
886 68. Sorry, hang up. 214
Uh-huh.
886 8340.
Just kidding, hang up.
I think it's because I got my hotspot.
Hello.
Okay, now we can hear you.
Wait,
I'm ready.
I'm gonna turn the audio down so there's not an echo. There we go.
All right. Everyone ready to proceed?
Sure.
All right. We're on the record in cause number DF 2115041. Councils, will you please announce for the record?
Peggy Richard or Ashley Mendez, petitioner.
Attorney Benny Powell, Assistant Public Defender, court appointed to represent Mr. Mark Anthony Salcedo.
All right. Those who intend to testify, please raise your right hands. Do you both swear or affirm that the testimony you'll give will be the truth and the whole truth? All right. You may lower your hands. We are set today for a number of different enforcements, all right?
Just one enforcement. We're set on my client's motion for revocation of suspension of commitment, as well as a new child support enforcement matter.
Okay, so father's enforcement for possession and access is not before the court today.
Correct.
All right. Okay, it's here. Exhibits. I see off the record.
I have a question. Do you ever Frenchie?
Huh?
Frenchie?
No, I don't.
Oh,
No. I had a German Shepherd, but he shed too much.
gotcha.
Right. And I don't see, oh, Attorney Sweet. Could you announce for the record?
Please wait for the Office of the Attorney General, intervener.
Thank you. I don't see any exhibits.
We have petitioners exhibits 1 through 5 that were approved Friday,
Oh,
May 1st.
let me go to Friday. I see them.
And then the state had exhibit A, which is what you were referencing earlier.
Yes. So state's exhibit A is admitted. Father has no exhibits, is that correct? And for petitioner's exhibits, I see 1, 2, 3, 4, 5. It's an exhibit.
The other 2 documents are her exhibits list and witness list, which were filed.
Oh, okay. So mother's exhibits 1 through 5 are admitted. Okay. So you all had an opportunity to speak. Were there any agreements that came out of that? Okay. So at this time, you can go ahead and read the agreement into the record.
So with regard to the child support enforcement matter that is set for today, the parties agree that Mr. Salcedo will pay the full amount of arrears beginning on June 1st, 2026, except that my client has agreed to reduce the child support arrears $5,000 if he pays the full attorney's fees judgment today that he's agreed to pay. However, if that is not paid today, that $1,000 reduction does not occur. And just to confirm, without the $1,000 reduction, the balance of child support arrears through and including April 30th, 2026 is $6,706.17. With that $1,000 reduction, it's $5,706.17. And we're confirming that amount as the child support arrears. And that will, until paid, continue to accrue interest at 6% under the statutory rules. For medical, cash medical, the balance that we're confirming today, but it's through and including April 30th, 2026, is $2,874.52. Mr. Salcedo agrees to pay towards the child support arrears $85 per month. That will begin June 1st, 2026. And towards the cash medical arrears, he will pay $40 per month, also beginning June 1st, 2026. Do we need to see if the state agrees to that breakdown before we go further?
More than likely. Attorney Sweet.
That's fine, Your Honor.
Okay. And then Mr. Salcedo has agreed to pay the amount of $2,908.79 today as his attorney's fees and cost judgment. And we are going to have the suspension of commitment language and the order, as well as community supervision requirement for Mr. Salcedo. That will be 3 years, or when he has paid off all of the arrears, whichever occurs first. We have also limited in the events we have to revoke suspension of commitment. We've limited the days in jail to 90 days. And I think that's it for that particular case.
Okay.
And the terms regarding community supervision and suspension of the amendment, it replaces the order from the previous enforcement.
That's correct. It's not in addition to, it will replace those terms. So he's not paying those arrears plus these new arrears.
Okay, that was going to be my question.
And not only that, but also any punishment, any jail sentence that was there, this is taking place.
That's correct.
Okay.
And then we've got, where we want to resolve the, Mr. Salcedo's motion for enforcement of possession and access, as well as my client's, request for attorney's fees on that issue, on that case. And then we want to also resolve the petition to modify parent-child relationship and my client's counter petition to modify parent-child relationship. I don't know if we need to stay on for that portion. I just wanted to give the court the option.
For the possession and access?
Yes, Judge, we're going to resolve all of those cases today.
Okay, I don't see why the state would need to be on. State, anything?
We're not modifying child support.
Then no, Your Honor.
Okay. Okay, anything else?
So
I'm sorry, you said that amount, right?
$2,908.79 due today,
Okay. I was making sure.
directly to my office. And I can send a link for a payment to Mr. Salcedo at his marksauce1@yahoo.com email address. Okay, on the motion for enforcement of possession and access, the parties have agreed to sign a joint notice of non-suit with prejudice to either party to refile any claim against the other for violation of possession and access through, or that would have occurred prior to today's date, May 4th, 2026. Specifically, Mr. Salcedo is non-suiting his motion for enforcement of possession and access. My client is non-suiting her request for attorney's fees and expenses in that case.
Okay.
And just,
I don't know, this time, important word that. We'll talk to my client real quick.
Okay, we're off the record.
Making sure he understood everything.
Okay, we're back on the record.
Yeah.
Your Honor, with regard to the petition to modify parent-child relationship filed by Mr. Salcedo on February 26, 2026, and my client's counter petition to modify filed yesterday, the parties are going to agree as follows. There was no passport provision in the current order. The parties have agreed to add that either parent may apply for, maintain, or renew passports for the children subject to standard Texas Family Law Practice Manual, passport and international travel provisions. And the parties will be ordered to cooperate in signing any documents necessary to apply for or renew a passport. The other issue in the current order is that the place of exchange was my client's mother's residence, but she has since passed away. Unfortunately, the parties are now agreeing to exchange the child outside of the school setting where that is relevant at the McDonald's located at 5337 East Grand Avenue, Dallas, Texas, 75225. And that should begin as of today.
75223.
What did that's not what I have written down. 75223. I don't know what I said, but that's what I have written down.
This is my head.
Okay. The parties are also agreeing that they're gonna add Halloween and Easter to the possession schedule, and they're gonna alternate which parent receives possession. For Halloween, the parties agree that father will have Halloween in odd numbered years. Mother will have Halloween in even numbered years, beginning at the time the children are released from school, or at 6 p.m. if the children are not in school, and ending at the time the children go back to school the next day, or at 10 a.m. the next day if that day falls on a weekend. For Easter, mother will have Easter in odd numbered years, father will have Easter in even numbered years, beginning at 8:30 a.m. on Easter morning and ending at 8:30 p.m. that same night. Parties are also agreeing to begin immediately as of today to communicate with each other exclusively regarding the children through app close. Each party is ordered to obtain and pay for their own subscriptions by the end of today. Each party is ordered to post all significant information regarding the children, unless the other parent already has access to that information. And we'll use the standard Texas Family Law Practice Manual in that provision as well. The parties are also agreeing to a mutual injunction against either parent attempting to negotiate modifications to the possession schedule through the children. And they're agreeing all of that communication will go directly through outlets. The parties are also agreeing to a mutual injunction against either parent allowing their spouse or significant other or any other person besides the parent to communicate on the parent's behalf on app close. And Judge, I'm gonna draft all three of those orders, the notice of non-suit, the agreed order on the child support enforcement, and on the counter petition to modify. And submit those to Mr. Powell where appropriate, and then I guess should I send that directly to Mr. Saucedo on the other two cases since you're not representing him on that? I don't want to miss that, or will you forward those to him?
You could send it to me.
Okay, that would be my preference, thank you. And I think that covers everything, Judge.
Okay.
That's the agreement as I understand it. I would just like to call my client to make sure he understands.
Okay. You both can call. You can go.
Okay, I'll call my client Ashley Mendez. Ms. Mendez, did you hear the agreement that we read into the record today? Yes. Do you understand that agreement? Yes. And do you agree to abide by the terms of that agreement and to sign an order that reflects those terms? Yes. I'll pass it.
All right.
No question, George. I'll call Mr. Saucedo.
Go ahead.
Mr. Saucedo, you state your full name for the record. Mark Anthony Saucedo. Mr. Saucedo, you heard the terms that were read into the record. And you agree with those terms? All right, and you understand that these terms address both the enforcement that was eventually enforcement you filed in his mom, and also the modification that you filed in his case. Yep. All right, and you and I spoke extensively about the enforcement that was against you. Is that correct? You understand that you understand all the terms that you agreed to regarding the enforcement. You understand that the court today is essentially you're agreeing to be put on probation for at the longest 3 years, and that if they absolutely file, you can go to jail for 90 days. Yes. All right, you understand the amount that you have to pay each month? Yes. Okay. You understand that we could have had a trial today, and Judge Bailey could have decided differently. So, yes. But this is your agreement. Yes. Great. Now, regarding the possession and access, those issues, you know what I'm saying? I was only appointed to represent you on the enforcement, correct? So the possession and access stuff, I'll let you look at that and see. The rest. So you really didn't have my advice on any of those issues, but that's your agreement. And I think it was easier for you to agree to that before the other stuff. All right, a lot easier. All right, trying to look back and forth, all right. Okay. You understand that mom's attorney will put together the orders that she'll send to me to review. So it's, Judge, I'll pass it with.
All right,
I just have a few questions.
go ahead.
Mr. Sasso, do you recall that the last enforcement order was agreed?
I just agree to everything you're trying to, me and her were on a better terms.
Objections, non-responsive.
The question, do you recall that the last enforcement order was agreed? Okay,
Do you also recall that you did not sign that order and it was entered without your signature?
No, I did not, I think I think this is still there, that wasn't one.
I'll ask the court to take judicial notice of the fact that the agreed order that is entered in June of 2024 does not have Mr. Salcedo's signature on it.
okay. The court takes judicial notice of all contents of the court's file.
Mr. Salcedo, do you understand that if you refuse without good cause to sign any of the orders that we have discussed today, so long as it contains all the terms that we discussed today, that my client has the right to file a motion for the court to sign and can ask for attorney's fees? In that case, I'll pass it to the judge.
Okay. Anything further?
Additional questions?
Okay, and counsel, you're preparing the order, right?
That's correct, all three.
Okay, great. So the court accepts the agreements as read into the record by the parties. You all need an entry date. How long do you need to prepare all three orders?
3 weeks, 21 days? That's max. I'll
Okay.
get it done before that.
So I can put you on the dismissal docket for May 22nd.
Is that a Zoom?
Zoom,
Okay,
yes.
I may be.
Yes, not in person.
Oh. nice. That's
But
a
if you,
Wednesday?
no, that's a Friday. That's a Friday.
I'm in final trial. What time?
Well, that's assuming that you all will need the day. You may not need it.
In case Mr. Salcedo doesn't sign, then we may.
Have to reset
I
it.
do have final trial that day in the free
I
first.
can get it sent to the clerk team, I can sign whatever you need to.
Okay. So Judge Lee runs the dismissal docket. It starts at 9:30 and it just pretty much runs with the what's that called?
Oh, you know,
Prove ups.
we settled that case that's on the 22nd. I'm free. I do apologize. I forgot we did that on Friday.
Okay. And you may not need this one. We just put it on there as precaution. So I added you all to the dismissal docket for Friday, May 22nd, 2026. That is in front of Judge Lee. The Zoom code is 961-1106-4392. Let me know if you need me to repeat it. No, okay. All right. Well, thank you all for working that out.
Judge,
You're
Thank
welcome.
you.
thank you for working through lunch, Judge.
No.
Oh, well, we're done.
Oh, good.